for a parking problem.
Or in your 23.
Yeah, we're on a 28 on truck when you're ready.
Go ahead.
One truck, white Lincoln X-ray 985 should come back up and
So you had 2000. Patrick Spalding.
10-4. If you can just throw a note in something like that, I'm going to be leaving a note on a vehicle if they can remove it.
Rockingham 505. 505 intercepting militant case for Athens. Complainant, soon to be ex, slashed her tires and has made threatening comments to her. She's concerned he might return.
And forgive this at 32.
10-4. You're assigned to a vandalism case in Athens. Did you copy the 505?
Yeah, 4. Look at that. No, 3 in Depot Street. Truck boy entry 5.
7435.
10-4.
10-4.
You can go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4. I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
449 1121, thank you.
10-4.
Code 4. 4.
Right, we have 535.
You have a great house.
535.
Should be. You guys know if our woman is tucked into a house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in still. There's no flight floor on their hair. He's got tie-dye shirt on. And number 21 is on.
We have separation. Excuse me. Hey guys, thank you for being here again with us. We've been doing a lot of Friday shows. Friday seems to be a good night for us, but now we're doing shows like every night because seems to be new developments in the Karen Reed case every day, right? So today we're going to go over the prosecution's rebuttal to the motion to dismiss. We're going to get right to it. Just so Daniel from Drunken Turkeys may be on later. He wants to come on, but he's also doing his own show. So if he can get on around 9, we'll do a joint stream and we'll go over. He's made some cool videos that really kind of look at all the various images of the taillight. And if he can't come on, I will just go to his channel and find those videos because I guess he's posted them on the channel. All right, so let's go to the document today. Now, I put on the thumbnail, let's get ready to rumble. This trial is happening, and I would say it's happening on time. This judge is not going to let anything derail that. And it's not going to be dismissed. It's not going to be postponed. And I don't think any lawyers are going to be removed. So let's just get ready to do this. Let's do this thing, right? That's the fairest result for everybody at this point. Yes, there's been misconduct, particularly on the side of the defense. No question. But let's just explore this. And there's other remedies for that. So let's just do the trial. All right. This is the Commonwealth's opposition to defendant's motion to dismiss for extraordinary governmental misconduct. Let me see if I can make this a little bigger. All right, that's pretty good. In case you guys want to read along at home. We'll get down to where I highlighted. There's a lot of highlights, so don't worry. It's not too long, but it's very thorough. All right. To prevail on a claim that the prosecution failed to disclose exculpatory evidence, the defendant must first prove that the evidence was, in fact, exculpatory. So this is remember the defense motion to dismiss was based largely on the taillight videos, not the taillight videos, the Sallyport videos, but also on the mysterious phone call that Brian Higgins made at 1:30, 1:31 or whatever it was, outside the Canton police station. Ooh. And Turtle Boy's going crazy now with theories of a ghost. He's brought in a ghost onto this case. So we're also going to go over after a really good new article by the anonymous Massachusetts lawyer. And he writes and puts together really well an analysis, which is very similar to what I've been saying for a while, but probably much better written. So, and some new points in it too. All right, so the prosecution points out that to say that the prosecution failed to disclose exculpatory evidence, the defendant first must prove that the evidence was in fact exculpatory. So, for instance, let's apply this to the Higgins phone call, which came outside. So Higgins arrived there, and we're going to see in a moment here that the video they have now shows he did in fact move around the vehicles because of the coming storm. So that corroborates his testimony. Went into the Canton police station to get the keys or move around the keys or something like that. Was there for a few minutes, and when he left, he makes a phone call. And the defense tries to call that as exculpatory. It's absurd. It's just a phone call. There's no reason to think he called anybody suspicious. The feds know who he called because they have his phone information. And they didn't ask any questions about it in the grand jury, the federal grand jury, because if they had, the defense would have keyed on it in the trial. That's just common sense logic. Not everybody likes logic. We know that, but if you don't like it, maybe true crime isn't your thing. That's right. Exculpatory. So this is what they quoted about. They quoted the criminal precedent, the case of Commonwealth versus Healy above, to say that it has to be, in fact, exculpatory. So it's not enough to say it was potentially exculpatory. Exculpatory evidence includes all evidence that tends to negate the guilt of a defendant or provide some significant aid to the defendant's case. And while rightfully broad, the conception of exculpatory evidence is not boundless. Only the millennial is boundless. In 2022, the Commonwealth provided the defense with approximately 90 crime scene service photographs depicting the condition of the defendant's taillight in the Canton Police Department. It further provided to the defense ring surveillance video of the defendant's broken rear taillight at approximately 5 a.m. So we've done videos that zoom in on that and show it pretty clearly. Oh, I don't know how to remove this. Let's see. I think it's the ad block thing. All right. That's all right. Sorry, my screen went jumpy. So they're going to document here just how clear it is that that taillight was broken. So nothing could have happened at the Sally Port. And it's about time, right? Because it wasn't documented as clearly in the trial as it should be, which kind of boggles the mind. This was always the focus for me. Get an image of that taillight. But it's, before we get too harsh on the investigators or on Adam Lally, let's remember that Karen Reed and her own team didn't realize it either for well over a year how important it was to show that the taillight was missing, whether it was missing pieces, for them to show that it was just cracked is what they wanted to show. And for the prosecution to show that it was missing pieces. This is something that for some reason people don't apply logic to these cases. My early thinking on this case was to try to discover that stuff, but that was not something that the prosecution, the previous prosecution, nor Karen's team really focused on. All right. So statements of the witnesses who observed the defendant's broken taillight around 5:30 a.m. So that is Matt McCabe, Jen McCabe, and Kerry Roberts. And the defense chose not to cross-examine Kerry Roberts at all. The Canton Police cruiser video depicting the defendant's broken taillight at approximately 8 a.m. We're going to see that in a minute. We showed it on the show last night, but I guess we're going to. All right, well, let me just read on. But we're going to see that the state has actually enhanced the image on that. So observations of a damaged taillight by the Dighton Police. People like to say that Officer Barrios from the Dighton Police said that the taillight was intact. No. Brother Counsel tried to say that. No. It's not what he said. Now, you might not believe his testimony, but he said the taillight was largely intact, but on the corner, it was missing pieces. And that's exactly what we see in the Sally Port. Most 75, 80% of that taillight is intact. It still is right now. It's just the corner piece that's missing. The taillight's a pretty big light. All right. This is something new added here. And automated vehicle location data from the troopers' cruisers who were assigned to the CERT team. I don't know why this stuff was not available in the first trial. This is the kind of thing that drove me absolutely crazy watching the first trial. I knew this evidence had to be available, and for some reason, they chose not to look into it. I don't know. Anyways, so what we gather here is, so the CERT team, this is the CERT team, unlike, say, the Norfolk County Detectives Unit, those guys are assigned to the Norfolk County. The CERT team, the Special Emergency Response Team, is not assigned to a county. So they're coming from all around the state. And what we learned during the trial is there were 8 people on the team, but 7 were available that day. But it takes a while to get them together. The Special Emergency Response Team is trained to work in bad weather conditions, things like that. That's why they were called in, because of the blizzard. So what they got was from the troopers' cruisers, as you can imagine, they have tracking devices on cruisers. This is the modern world. And they were able to go look at and see that those cruises from the troopers assigned to the CERT team were actually at 34 Fairview at the time, which would make it impossible. They were there before this, half hour before the Sally Port. The Lexus arrived at the Sally Port. So it says here, evidence that the CERT team was on Fairview Road before the defendant's vehicle arrived at the Canton Police Station. Lieutenant Kevin O'Hara of the Massachusetts State Police CERT team testified at trial, and his automated vehicle locator records confirm his arrival at 34 Fairview at 4:56. At that time, the Lexus was on the tow truck and halfway there. The Lexus didn't arrive till after 5:30. Didn't arrive into the Sallyport until 5:36. All right. So these guys are there. They're setting up in a very small area. And we saw a new little clip of footage from WB's at that. We don't know what time. I've said for a long time, and I tried to find out this myself. What the state should do is contact WBZ News and find out what time the news truck was there and what time it began filming, and try to get some footage from it, right? I don't know. I tried over a year to get them to do that, but I don't have access, so wasn't able to do it. Sorry, brief cough drop. So Lieutenant O'Hara additionally testified that his arrival was preceded by one other trooper from his unit, Trooper Jason. I won't even try to pronounce that name. So he arrived at 5:44. So the first state trooper to arrive there was one of the members of the CERT team at 5:54. And that's confirmed by the data from his vehicle. The defendant's vehicle arrived on the back of a flatbed tow truck at the Canton Police Station at 5:30. And actually, it was 5:31. The defendant also repeatedly represented in the media and postured at trial that her taillight was broken at 5 a.m. by striking the victim's parked vehicle in the driveway of the victim's home. Well, the Commonwealth has provided substantial evidence, including accident reconstruction video from its expert. So this is new, Judd Welcher. We knew they had a new expert on this, but this was not something that we saw in the first trial. So they have accident reconstruction video from this expert demonstrating otherwise. In other words, that taillight could not have been cracked by the very low speed collision that happened in the driveway. So again, and this is a lot of people, and even back at the, over a year ago, former police officers and former federal police officers that I talked to were convinced that Karen backed into John's Traverse on purpose in order to cover up the damage. And it's a reasonable theory. The problem I've always been against it is that if you were going to do that on purpose, you'd go in at a pretty high speed just to make sure, and she went in at an extremely low speed. This is when I used to live in Boston. You'd bump, you got to learn how to parallel park in a space where you have 2 or 3 inches in front and 2 or 3 inches behind. And the only way to do that is to kind of bump and grind your way in. So you kind of know that these low-level bumps, they don't crack taillights. So let's continue. Beyond unsupported claims and vague innuendos, the defense struggles to establish how the condition of the defendant's broken taillight in the Canton Police Department Sallyport is in fact exculpatory, or the most critical. Now he quotes from the motion to dismiss, or the most critical and highly contested issue in this case. Just to go back to what I was saying last night. Just to go back to what I was saying last night. If you're forced to make weak arguments, then even in the areas where your argument might be a little bit stronger, it's probably not good. So the very fact that the defense is still trying to suggest that the Sallyport was tampered with, that the Lexus was tampered with at the Sallyport, kind of tells us how weak their position really is. And this is what those of us with common sense made this determination a long time ago once we knew the evidence of the timelines. It is what it is. There was no time to do this. And that's why whatever happened, whatever video they want to find from the Sallyport, it's not going to be exculpatory. Let alone if that's their most critical evidence, they got nothing. They got nothing. All right. Despite claims to the contrary, the defense never filed a motion to preserve or in its perpetually evolving theory of the case, did the defendant specifically request prior to November 2024, this past November, surveillance video from the Canton police station? So they're going to try to claim that in the original preservation order, all the way back a few days, so this was the day Karen was arraigned, that they put in the motion to request the preservation of all physical evidence, including anything present or near the decedent at the time his body was discovered. That does include everything in the world. Okay? So we don't have, for instance, surveillance video from Trooper Proctor and Buchanan when they arrived at the state police, at the district attorney's office with the initial evidence, which would have been, 7:30 at night. There's no video of that. There would be video existed at some time, but that's not in discovery. There's no video of them walking through the hallways, entering the building. There's cameras in every room in that building. There's no video of it. There's no video of them taking John's clothing out of the wet clothing out of the evidence bag and putting it on the table just outside the evidence room to dry. There's no video of that. So is the state in violation of some preservation order because there is no video of that? No, because nobody, and likewise with the Sally Port, the defense never asked that to be preserved prior to this past November. Now, that's not to say there isn't, if the state has something like that, they should put it into discovery evidence, and they did. Unfortunately, some of that came just before the trial, but it wasn't something, again, going back to the defense, despite they're looking for every angle, and this is the only case they're working on, they took a year, more than a year, to figure out the importance of showing that the taillight was only cracked before it arrived at the Sally Port. So if the defense, with all these lawyers and Karen, if it took them that long to figure that out, is it really that surprising that the prosecution and the Canton police didn't really think that through either? I mean, I wish that they would have and went to get that Sally Port, but they have other cases, other things that they're involved in. It's just so, if the defense didn't think of it, it's not really surprising that the other people didn't. The only person that might have thought of something like that was me. I'm sorry. I mean, those are the kind of questions that I was asking back in the summer of 2023. I know that sounds obnoxious, but you can go back and look at the videos. Those are the questions that I was asking. The Commonwealth could not reasonably have anticipated the defense's ever-evolving third-party culprit claims, nor to this day made the Canton Police Department video pertinent to their amorphous and fluid claims. I guess McLaughlin must have wrote this. She has a pretty good turn of an adjective. Not saying Hank doesn't. Maybe he does too. But I can usually tell McLaughlin's writing. Nevertheless, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor. Prior to that, the prosecutor had not been alerted to its existence by investigating officers. So I'm not sure why it came up. We're not going to learn that in this document, and we don't have access to that grand jury testimony. Why did it come up in there? Did the feds ask about it? Did Michael Proctor remember seeing a surveillance camera? We don't really know. So once the state did learn of this, promptly, it says, on April 4th, 2024, so last year, the Commonwealth provided the defendant with 9 surveillance videos in its possession, consisting of video footage of the main driveway of the Canton Police Station. And I guess the Sally Port is named the O'Keefe Sally Port. I didn't know that. I don't know. I'm not going to comment on that, but it doesn't mean anything, but it's just a little bit noteworthy. Notably, the quality of the video is poor in certain portions. However, that is the condition it was recorded in and the condition in which it was received by the prosecutor. So it's a shitty surveillance system. I once had a shitty surveillance system in the bar that he owned. Now, it's unfortunate that a police station has a shitty surveillance system, but it's a small town, and it's not something, I guess it's been remedied since then, but at the time, they had a shitty surveillance system. The Commonwealth has produced evidence that since January 2022, the Sallyport camera was replaced due to its defective condition. And during the first trial, the Commonwealth called the technology director for the town of Canton to testify about surveillance video systems throughout the town, and he was cross-examined by the defense. The Commonwealth filed its certificate of compliance. Let's see. During the defense's televised motion to admit third-party culprit evidence, Attorney Yannetti made representations about the Canton Police Department's surveillance videos. Following that hearing, on April 17th, Lieutenant Tully sent prosecution team members an email stating, I spoke with Police Chief Rafferty, this is Canton Police Chief, and she reviewed the video of the SUV arriving at the CPD. This is a grammatical thing, but it says she reviewed the video of the SUV arriving at CPD exists. That's just really poor English. So maybe it wasn't McLaughlin. And we should have it, unless they're quoting from it, but there's no quote. Oh, no, I'm sorry, there are quotes there. All right, so that explains it. And we should have it. Contrary to what defense represented on Friday, the video depicts the vehicle entering the Sallyport and the crime scene tape being put up. She is putting it on a thumb drive. All right, so after they finally started focusing in April, she had seen at the hearing, she said, oh, maybe we do have some more video, and they went looking for it. It just wasn't something they thought to look for earlier. You can say they should have, but again, nobody thought to look for the video of Trooper Proctor and Buchanan putting John's clothing out to dry on the table either. So there's just no reason to think that they're that thorough to think of this stuff, because they're investigating other cases. Chief Rafferty has a lot of other things on her mind besides the Karen Reed case. Troopers Proctor and Buchanan had a lot of other cases that they're investigating. They don't obsess over Karen Reed case like we do. The prosecutor had not previously received this video or knew of its existence. Subsequently, the prosecutor requested that both the Mass State Police and the Canton Police Department produce all relevant and material surveillance video. So the prosecution was taken by surprise that this late in the game, just days before the beginning of the trial, this new video surveillance that's emerging. It sucks that that's the way it goes down. It looks suspicious from that 2,000 feet flyover view, but it's not in actuality suspicious. It's just human behavior. The Commonwealth provided the defense with surveillance video entitled Interior Sallyport Back Wall. Now, here was a problem that they ran into. Notably, what was produced to the Commonwealth and provided to the defense was this wasn't the problem, it'll come up, was inverted surveillance footage due to the camera's settings. So we've talked about the famous inverted video. The day that was shown in court, or the day that it was exposed as a problem, Thomas Fleming talked to me, and either because he's smarter than me or because he studied this at school more recently, he said that's how cameras are, or most cameras, or many cameras are. They record in mirror, and then it reverts back on play or something like that. He said even in older cameras, they would put a physical mirror inside the camera. There's some production reason for that, or something the way, I don't know. I don't know the technical reason for it. I just know when he told me that, I looked it up, and it was true. I looked it up right away using like ChatGPT and stuff like that, and anybody can figure this out. So there's nothing suspicious about it, but the state has now done a pretty cool thing to debunk it. The Commonwealth did not manipulate or alter any video and entered as a trial exhibit the video in the condition it was received. Contrary to the defendant's representations that the Commonwealth's intention was to mislead or deceive the jury by introducing the inverted video, the defendant fails to mention that after the defense altered the evidence to correct the image to appear consistent with the human eye, the Commonwealth played the entirety of the corrected yet altered video, which reveals that Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight. Further omitted from the defendant's filing is that Trooper Proctor's DNA was not on the right rear taillight. So had he tampered with the taillight, would they have found, they did test that taillight for DNA because they were looking for John's. Wouldn't they have found Proctor's? But again, I remember everybody's in on it. Okay. After the trial, a certified forensic video technician employed by the Norfolk District Attorney's Office reviewed the surveillance footage that had previously been produced to the defense. Recognizing that the video was extremely dark with minimal visible detail, the video technician clarified the video footage. And on October 10th of this past year, the Commonwealth produced to the defense clarified videos. So when the defense is out there now trying, they gave us brand new video in October. No, they gave you the same video, just clarified it through in a way that's apparently allowed or approved. They just changed the lighting on it so things can be more clear. So reports detailing, and they also gave them reports detailing this clarification process, associated hash values, and extracted still images from the Canton Police Sally Port. Furthermore, the video technician clarified video images from the Canton Police cruiser taken at 8:23 a.m. The Canton Police Department Interior Sally Port front wall footage from January 29th, 6:13 p.m. Now, I don't know what they were filming at 6:13 p.m. Because that's long after the CERT team had found the pieces. In fact, the CERT team wrapped up and went home at 6:22. And the Massachusetts State Police Crime Scene Services Section photographs, each depicting the same damage to the right rear taillight, and encapsulated those images in a substantive report provided to the defense. After trial, on August 21st, the Canton Police Department provided the Commonwealth with 2 additional videos. Video from the interior Sally Port camera on January 1st, 2022, depicting the camera captured all video in inverted fashion to rebut the defense's suggestion that the video had been tampered with. Now, you may remember back in December when there was a new list of discovery material, when I read it on the show, all it said was what was there, and it just said new video from the Sally Port at January 1st. And I'd speculated, I said, that's what it is. It's going to show that the video was inverted. And so FKR out there, the FKR crowd doesn't like it, but my batting average is pretty good. So anyways, they have video from January 1st, almost a month before, and that shows that the video on that system was set to record inverted video. It's just the way it is. They also put in video from the interior hallway and exterior of the Canton Police Station that shows Brian Higgins at the Canton Police Station during the early hours and depicts Mr. Higgins moving his law enforcement vehicles due to the snowstorm. So this corroborates Brian Higgins' testimony as to why he was there. Now, if Brian Higgins had just been involved in some murder plot, was he going to be moving around those vehicles? He probably would have other things in his mind, right? These videos were provided to the defense on October 10th. Prior to their production, the prosecutor was unaware of the existence of these videos. So it does suck that all this stuff comes out. They can't get their shit together. It's troubling. And when I say they, I mean Canton Police or the town of Canton. It's not suspicious. It's just troubling. I mean, it almost feels like after this second time, maybe more video will come out. I mean, it won't stop coming out. It's just going to keep coming out from the Canton Police Station. It is troubling, but it's not suspicious because, again, it's not material. There's so much evidence to show that the taillight was missing pieces and damaged exactly the way it was seen later on in the Sally Port. And none of this has anything to do with the troopers or the prosecution. The defense boldly claims that the surveillance video of Mr. Brian Higgins and in and outside the Canton Police Station proves that he perjured himself before a federal grand jury. This claim is extremely prejudicial and false. In support of this claim, the defense cites to a federal grand jury transcript. So that's redacted. But again, we see over and over again the defense citing things that aren't true. Even just in court last week saying that Hank Brennan never mentioned the pause. But I've showed the video on the channel here where he did. So Higgins and Brian Albert were thoroughly cross-examined at trial. Additionally, the Commonwealth provided the defense with 167 pages of access card swipe records throughout the Canton Police Department. They had electronic locks. Mr. Higgins was cross-examined about his movements through the Canton Police Department that day. On January 28th, the Commonwealth of this past year, the Commonwealth provided, January 28th this year, so a month ago, the Commonwealth provided the defense with surveillance video from the main driveway side exterior Sallyport that depicts a different camera angle. So again, it's troubling. All this stuff on and on about the video, and still just a month ago, they turn in yet new video. I don't know why they can't get their shit together over there. I don't get it, but that depicts a different camera angle of the defendant's vehicle arriving at the Canton Police Station Sallyport. Notably, consistent with other videos received from the Canton Police Station Sallyport, the quality of the video is poor. There was absolutely nothing depicted in this video, however, that is exculpatory or undermines the consistent evidence that the defendant's right rear taillight was broken and pieces were missing prior to the vehicle being towed from Dayton. After directing a review of all physical and data files, this video was located within a paper case file of investigators. It looks bad, right? I mean, I'm not going to say it doesn't. It doesn't. It's not going to affect things here. It's just human error. But all the error in this case seems to revolve around Sallyport video, which at one time, for a long time, would have been deemed irrelevant. But certainly, it's strange. It's not strange, but it's frustrating that this stuff is still coming out. And does somebody have a thumb drive in their pocket somewhere else with something? Who the hell knows, right? After inquiry, it was learned that an investigator obtained this video from the Canton Police Department in 2022, and it was placed in a physical case file and never provided to the prosecutor or multimedia assistant for download. All right. Investigator, one of the troopers, I guess, but I'm not sure, because the Canton police were not on the investigation. But think about this. If there is something suspicious, evidence of a conspiracy on that thumb drive, why does it even exist? So if you're going to go with they hid this thing in some secret suitcase only for it to emerge now, I mean, how hard would it be to throw out a thumb drive? A thumb drive is the size of a thumb. Just drive down the street and throw it in the woods. Throw it in the sewer. It's never going to be found. So the fact that it's emerged now, though annoying, really doesn't in any way support the idea of a conspiracy. If there was a conspiracy, that thing would have been destroyed. All right. Although the prosecutor was wholly unaware of this video until recently, the Commonwealth does not dispute that the video was in its custody during the defendant's first trial. Had the prosecutor known about this video, it would have been produced as every other video known to the prosecutor was. So this must have just, I can imagine Hank Brennan kicking some ass that day at the DA's office. He's like, what is going on here? Why is this stuff emerging on January 28th? What am I doing with you people? I would imagine he was a very frustrating day for him. But in any case, it's not relevant to anything. Even in circumstances, it's only relevant in that they can exploit it and make it look like it's something suspicious. All right, so even in circumstances where the prosecutor fails to disclose evidence a defendant is entitled to receive, there must be a showing of irredeemable harm irremediable harm to the defendant. This court must examine the extent to which the defendant was disadvantaged in defending herself when considering the prejudicial quality of exculpatory material evidence. In measuring prejudice, now this is a quote here, so it's going to come from another case precedent. In measuring prejudice, it is the consequences of the delay that matter, not the likely impact of the non-disclosed evidence. And we ask whether the prosecution's disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting his case. So they've given the evidence in January, which is plenty of time for them to potentially make use of it. The defendant cannot show irremediable harm to her right to a fair trial as it relates to the Canton Police Department surveillance video. While the January 28th production was untimely, the poor quality of the video makes it difficult for either party to benefit from. Furthermore, this video depicts the same event that was contained on the surveillance videos produced on April 4th and April 23rd, simply just from a different angle. So what the defense is saying is this new video has an angle that perhaps shows the condition of the taillight better. We haven't seen the video. The state says no. And the judge she can look at that evidence. Further, while the Commonwealth will argue that the videos from the Canton Police Station Sally Port are inculpatory, the defendant benefited during the first trial by suggesting without any substantive evidence that the poor quality of video and or gaps in time due to an improperly functioning camera system were caused by an improper police investigation and systemic police misconduct. So it sounds like the prosecution is going to say that these new videos are actually inculpatory. So the fact that they weren't available to the defense in the first trial actually helped the defense in the first trial. Now, that remains to be seen. We don't know that without looking at the videos. In November 2024, the defense made an informal discovery request relative to the Canton Police Department videos. The Commonwealth and Canton Police Department facilitated the request, and on December 12th, this past year, in the presence of the defendant's expert, it was discovered nearly 3 years after the incident that the footage on the DVR was overwritten and the system no longer maintained the original surveillance footage to be forensically extracted. This also marked the first time that the defense had made any request for metadata or logs pertaining to those videos, as neither the defense's February 2nd of 2022 nor October 5th, 2022 motions or corresponding orders make any reference to such materials. They don't even make any reference to the Sally Port. All right. So if Drunken Turkeys comes on, we're going to look with him at the videos that he's put together. And if he doesn't, we'll just go to his channel and I will link to it. But we'll take a closer look at these taillights and see just how convincing it is. All right. Now, on to the Jennifer McCabe issue. It was during the third week of trial on May 7th that the defense produced reciprocal discovery to the Commonwealth regarding location information of Jennifer McCabe's cell phone. So Rich Green decided to check the GPS or the Life 360 or something, but somehow he checked into it during the trial and found that Jen McCabe's phone was at the address or near the address of Officer Lank's house. So 3 days later, on May 10th, in anticipation of her trial testimony, the Commonwealth met with Jennifer McCabe, as it does with all its witnesses. Lieutenant Tully wrote a police report memorializing the meeting and explained, when asked, why her cell phone would have been in the area of the residence of Sergeant Lank. Jennifer stated, this is quoting from Tully's report, Jennifer stated she was with Kerry Roberts, who was picking up her daughter at the residence. Jennifer did not speak with Michael Lank while at the residence. So the issue was The defense is saying that once they submitted this during the trial, during the third week of the trial, that the prosecution tipped off Jen McCabe that they had this. And the defense didn't want, the defense was hoping to catch Jen McCabe in a lie. They were hoping to say on the stand, did you go to Officer Lank's house? And if it was the first time she was hearing it, they were hoping she'd say no. So they're accusing the state of tipping her off. But there's no way to prove that because, as Tully said, as the prosecutor said, they're going to prepare all of the witnesses just before they testify. That's legal. That's normal. That's customary. Now, the other issue, though, was that Tully did not memorialize that in notes right away, which you would think that's probably normal procedure. So the defense did not have access to those notes until he submitted them at a later date, and that later date was after Jen had already testified. So Miss McCabe, it says, met with Tully, looked at some video, and was asked a single question. Now, remember, that preparation, Jen is the main witness. She was with, actually, I don't know, Jen did not go on that vacation to Aruba, but she knew John going back 8 years. Her daughter's best friends with John's niece. So she had a lot of interactions with John. So that's something the prosecution would have been discussing. But then most importantly, she was at the waterfall. She was at the after hours party. She was communicating with John as they were driving there. So she, really, other than Karen, she's the last person to ever talk to John. And then Karen comes to her house at 5:30 in the morning. So, and then they ultimately end up at the scene where they discover John. So Jen is the most, I don't want to say the most important, but she's the busiest witness involved. There's a lot to discuss with her. So they only asked the one question, Lieutenant, about the video. And that report wasn't available at the time, but it was available before Lieutenant Tully testified. So Attorney Jackson vigorously cross-examined Jen McCabe, and she detailed her reasons for being in the driveway of Lank's home. During cross-examination, Attorney Jackson elicited testimony that it was Tully who asked Jen McCabe an open-ended question. Did you go to Michael Lank's on the 30th? So this is before he got the notes. The defense got the notes from Tully's report. Attorney Jackson then questioned Jen McCabe about whether there were any follow-up questions or whether the Commonwealth revealed the defense's report. And Jen testified that neither occurred. And that's what ultimately came out in Tully's notes. Notably, the Commonwealth produced Tully's report once it was available to the defense prior to Tully's testimony. Tully was available to be cross-examined about his recent meeting with Jen and or any other perceived inadequacies in the investigation related to Jen McCabe's phone's whereabouts. The defense declined to. The defense declined to do that. Now, in the car with Jen McCabe was Kerry Roberts. They could have asked Kerry about this stuff, about the visit to Lank's. When I said they were in the car going to Officer Lank's, and they chose not to cross-examine Kerry Roberts at all. As it says here, the defense relinquished their opportunity to cross-examine Roberts about the event in Sergeant Lank's house. So if it was so important, this is what they're saying. It's not really relevant or material here. If it was so important, why didn't they ask Kerry Roberts about it? So again, this is why I'm not saying that the defense doesn't have a little bit of a beef here, but it's not going to be enough beef to create a mistrial, not even close. So we're going to move on. Most enlightening on the defendant's lack of prejudice is that on June 18th, Jackson stated, quote, during trial, they interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to the report until after she testified. The interview, the report, and the completion of the report were all done before her testimony. I mean, I agree it's a little shady on the part of the state to do this, but immediately the court offered, do you need to call her again? So this is the judge. I remember this. She said, do you need to call Jen McCabe again? And I remember Jackson was frustrated. He said, no, Your Honor, I'm not. That's not, I think the court understands that's not my point. My point is not that I need to call Jen McCabe back. I've done the damage that needs to be done on Jennifer McCabe. That's what he said in court. The court said, I'm sorry, I missed that. You've what? And Jackson repeated, I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. So he kind of screwed himself there. If he's saying it didn't impact things, then why are they going to use that as a basis to dismiss this new trial? When given the opportunity to remedy any perceived prejudice, the defense declined to do so. Now, the last thing was the juror dismissal thing. The defendants claim that a lieutenant of the Massachusetts State Police was in charge of jury security is patently false. At no time did Lieutenant John Fanning have contact with, nor control or influence over, the trial jury. Nor was there any jury tampering that deprived Karen of her constitutional right to a fair trial. The defense's brazen misrepresentation previously proffered in media interviews in direct violation of the impoundment order of juror discussions and sidebars, solely to mislead the public and jeopardize the integrity of the judicial proceedings, are false and dishonest. The executive branch of government is separate and distinct from the judiciary. That's an very important point. The executive branch of the government, which is what the state police are under, is separate and distinct from the judicial branch. The governance of the jury is solely within the power of the trial court and the sworn court officers. So what they're saying is the bailiffs and all that stuff, the court officers, they work for the judicial branch. They don't work for the state police. The state police have no authority over them. The defendant's first trial raised significant safety concerns for both parties, members of the victim's family, witnesses, court staff, media, and the public. To effectuate both the defendant and the Commonwealth's rights to a fair trial, this court ordered a buffer zone. To enforce the buffer zone and maintain order, approximately 50 uniformed officers from the state police and other local departments were deployed each day on foot, motorcycle, and bike in the area directly surrounding the courthouse. Additional law enforcement resources were available in proximity to the courthouse at the Dedham Police Station. As a superior officer assigned to the Norfolk District Attorney's Detective Unit and the only supervisor who was not a trial witness, Lieutenant Fanning was one of the commanding officers who was involved in the safety and peacekeeping efforts occurring outside the courthouse. So they kind of had to go with Fanning because I'm not sure how many lieutenants. I think it's just Tully, but Tully was testifying in the case. So yet somehow the defense conflates that fact to misrepresent that Lieutenant Fanning, therefore, improperly influenced and tampered with the jury. To do so, the defense omits the remainder of Assistant District Attorney McLaughlin's statement to the court, and that's redacted. On February 17th, so a couple weeks ago, Attorney Jackson to the media said that Lieutenant Fanning was the very person governing the jury. Lieutenant Jackson also stated, despite representations in this court filing, that he had no specific evidence of jury tampering. So what is he even talking about, Jackson? However, conveniently omitted from the defense's filing in extrajudicial statements is the following from McLaughlin, and that's redacted. I'm sorry. At no time did Lieutenant Fanning. All right, so let's just emphasize this. Actually, let me stretch for a moment. At no time did Fanning enter the Norfolk Superior Courthouse during the trial. At no time did Lieutenant Fanning enter the Superior Courthouse. Moreover, he never saw, let alone spoke, to any member of the jury. Furthermore, there is absolutely no evidence that the dismissal of the juror was improper. And the rest is redacted. I'm not going to repeat at length, but this juror absolutely, we don't know what Judge Cannoni was told, but she certainly was told part of a story. I know the rest of it. Oh my God, this juror should never have been on the jury. And I think she should be charged with something. I mean, I don't want to, not that I want to see any harm come to her or anything like that, but this is someone that lied to get onto the jury and lied every morning when she raised her hand and took the oath to say she hadn't followed this in the media. She, on at least 2 occasions during the trial, with jury duty the next morning, was drunk going into bars and shouting out she's a turtle rider and she's going to acquit Karen. So that shows that she violated. When you get on that jury, you have a jury questionnaire and then you have a voir dire. You don't want anybody on the jury that has strong opinions about the case because they followed this in the media. On either side, you want a fair trial. If I don't live in Norfolk County, I consider myself a fair and objective person, but I understand that I would not be eligible to be on a jury on this trial, a juror. So she understood it too. But this is the power of this cult, is that, I don't know, people don't think straight, I guess. It's like a new religion. It's almost this. What she did was the 2024 version of the Christians not fighting back in the Roman Colosseum as they were sacrificed to the lions. It's a religion, and you do irrational things. The defendant's preposterous claim, one that Attorney Jackson has stated that he had no specific evidence of, should be rejected. So, of course. And so they not only does the Commonwealth recommend that they dismiss, obviously, the motion to dismiss, that they deny the motion to dismiss, but also a request for an evidentiary hearing. So that evidentiary hearing would probably mostly deal with the Sally Port stuff. I don't think there's a chance, but given how late in the game this is, I don't think that's going to be happening. All right. I'm just going to look quickly and see if I've heard from the turkey. I don't know what time his show is, so he may not be able to come on because he starts his show. I don't know what time it was starting. Yeah, and he hasn't messaged me. So, I don't want to stay on till 10 o'clock, so we probably won't have the turkey on, but hopefully we'll, because, Daniel's pretty cool. And he is interested in this topic going about the taillight. All right. Now, let's go over the anonymous lawyer's article from today. It's a very good one. All right. And then we'll go to Turtle Boy's post, which when you see it in light of everything we're discussing today, you'd be like, he's either an idiot or he just knows that his audience are idiots and he's basically doesn't mind trying to dupe them. All right. This is from anonymous Massachusetts lawyer. One of the foundational tenets of the Free Karen Read movement is the belief that the taillight evidence found at the crime scene was planted. This assertion is at the heart of the Reed's recently filed motion to dismiss, which posits that the supposedly missing video footage at the Canton Police Department headquarters is exculpatory because it would show that Reed's taillight was still mostly intact at the time her vehicle was impounded, thereby offering support for a theory that pieces of it were subsequently taken from the SUV and planted at the crime scene and on John O'Keefe's clothes. All right. Ooh, this makes me feel better because I was really struggling to read that motion. And I was wondering if I was having a stroke. I'm like, why am I not reading this so well? But then this is something that's written much better. I was able to read it much more smoothly. I guess it's not me. Before, and there were parts of that, I'm not trying to criticize, it just was choppy to read. So before getting to the myriad reasons why this belief is silly It's worth stepping back and considering how this belief came to be so widespread in the first place. What actual facts, real or imagined, led anyone to even suspect that the taillight evidence could have been planted? As far as I can tell, here are the facts and circumstances that contributed to that. Number one, the fact that no taillight pieces were found by the police and first responders at the scene on the morning of O'Keefe's body was found. Now, I've addressed this many times. After I had the meltdown episode, I talked to Turtle Boy on the phone for about an hour, and that was his main reason, probably still is, even though it's been debunked, but he's got to cling to it. But that was his main reason at the time for believing there was a conspiracy. Number two on the list here, the fact that the taillight pieces were recovered on separate occasions over the span of many days. Number three, the fact that at least one of the people who found taillight pieces was Michael Proctor. Trooper Proctor. Sorry, I can't do the Turtle Boy voice. Who the conspiracists had linked to the Albert family. Number four, the fact that at least prior to the release of the ARCA report by the feds, which first posited the cocktail glass theory, none of Reed's defenders had managed to come up with any other non-inculpatory explanation for how the taillight pieces came to be at the scene. In other words, believing that Reed was innocent required believing that the taillight was planted. This is what I've always said. This is an either or because of those taillight pieces. Those taillight pieces were found that evening by the CERT team, not all of them, but at least the first couple, and all the pieces would have had to been planted, and the main corner taillight piece was the first one they found. They found it at 5:45. So either the Lexus struck John, or somebody planted that piece. There's no middle ground. So if you're going to believe Karen is innocent, you have no choice but to come up with a way that taillight piece could have been planted. All right, so that's really all there ever was, he says. And as you can see, particularly through the lens of hindsight, this is an incredibly weak factual foundation for adopting such a wild conspiratorial belief. And as we saw at trial, literally none of these four prongs held up to scrutiny. They didn't, but it needs to be presented much more tightly, and preferably with some kind of a graphic that can show the timeline. The reason no taillight pieces were found by the police initially at the scene is because there was an active blizzard. A blanket of snow was covering the ground, and the area where most of the taillight would eventually be found along the curb was covered and packed plowed snow. The only area where the police made any, when he says the police, he means the Canton police. The only area where the Canton police made any attempt to look for evidence was in the area right around the body, and he was several feet onto the lawn, where there's no reason to believe any taillight should have been. Remember, when the Canton police were looking, they didn't know that it was a hit and run. The fact that the taillight pieces were found on multiple occasions over several days is easy to understand. It was also due to the blizzard. The CERT team, which found the first pieces, only searched a narrow strip of ground by the curb, having to dig through 3 feet of snow to do so. On subsequent occasions, and people always bring this up, there wasn't 3 feet of snow. There was 22 inches of snow, but the area where the main taillight piece was found, where the curb was, and also the shoe, was 3 feet, because that's where the plow mound was, and you had the 22 inches of snow on top of that. And Trooper O'Hara described that very vividly. On subsequent occasions, other members of the Mass State Police team searched different areas and found 2 more pieces. As the snow continued to melt, more pieces were found. See, the Karen Reed people don't know that snow melts. They don't know. I don't know where they've been. Maybe they grew up in Florida. It hasn't snowed much around here lately. I don't know. So as the snow melted, more pieces were found, including shards that were likely kicked up by passing plows. All of this makes complete sense. So yeah, that evidence got moved around, or could have. Finally, as even the FKR crowd's least honest propagandists concede, there's simply no way that Michael Proctor could have planted the taillight by himself. Indeed, Turtle Boy's theory, which he expanded upon in several tweets today, is that Proctor ripped off pieces of taillight the second the Lexus entered the Sally Port, handed them off to a guy he calls Ghost Man. And Ghost Man then whizzed across town to 34 Fairview, where he somehow managed to plant the taillight under 3 feet of snow, 3 feet of plowed snow, and right by O'Keefe's missing shoe, right under the nose of the CERT team members and the others standing around the scene, including Lieutenant Tully, who's documented it in pictures. I guess if the guy is a literal ghost, it's possible, but otherwise this seems like quite a stretch. So yeah, the ghost theory, it has to be an action. In order to get down that crime scene into that tiny crime, it's about the size of 2 parking spaces that they're digging. 7 people digging. WBZ there, other cops around, Lieutenant Tully taking pictures. Most of these people would be familiar with Trooper Proctors and Buchanan. Certainly Tully would be, because they worked for him, basically. Somehow this ghost, well, that's right. It was, so under this theory, it wasn't Proctor Buchanan, it was the ghost. So there's another person that's been brought into the conspiracy, or maybe it was some ghost that they conjured up through some dark rites, some ancient procedure that conjured up a ghost that you could send into battle, like Lord of the Rings. So this is from Turtle Boy. Karen Reed's motion to dismiss is much stronger this time due to all the blatantly withheld exculpatory evidence. Again, none of it was exculpatory. We now know that a video was given to the defense on January 28th from outside the garage, which would show who the mystery ghost man next to Michael Proctor was, who entered and then left the garage during the 20 seconds of video from inside the garage that was deleted. Unfortunately, this new video is too blurry, which Hank Brennan claims was due to bad technology. However, the ghost man is dressed a lot like the 3 unknown CERT team members. Oh my God, I don't understand this. How does anybody fall for this? How does anybody fall for this? I don't understand it. So Ghost Man is, in Turtle Boy's imagination, circled in purple here behind the Lexus. And all you see is a silhouette. It's someone in a winter jacket. It's during a blizzard. But he looks at that and says, wow, he's dressed like a CERT team member. I have to be helped to understand. I can understand how people who've been following this case superficially, and maybe they watch Turtle Boy in the Glare, who gives them very ridiculous levels of evidence, maybe they're fooled. But if you actually watch the trial or you're looking at the real evidence, there is no way an even average intelligent human being could be fooled by this. There's no way. There is no way in the world. I'm sorry if that insults some people. I'm baffled. I don't understand. Even someone who with a 90 IQ should be able to figure this out. This is so obvious. I don't get it. And then you see from the picture the Turtle Boy post there, interestingly, at the crime scene with the CERT team shoveling. So look at that CERT. So this is why he has to now say it was someone on the CERT team, because it would have to be. Because there's no one else could get into that. This is what I've been saying for a long time. Now Turtle Boy's finally coming around. There is no way that somebody could have got into that crime scene unless they were part of the CERT team. There's no way. Look at that small area that they're shoveling out. It's just extraordinary that people fall for this. So Anonymous continues. The fundamental problem here is there's no reason to posit such a crazy theory at all. I love that he goes into science stuff here. And this is all history of, I watch a lot of science videos. I used to get science magazines when I was a kid, like in the 6th, 7th, 8th grade. I'm not a scientist. I just enjoy science. So the fundamental problem here is that there's no reason to posit such a crazy theory. Einstein's theory of relativity was a wild departure from consensus scientific views at the time. But the reason he came up with it was that there were real, observable, well-acknowledged phenomena that Newtonian physics could not adequately explain. And this is true. The whole world of physics was working on these problems for a couple of decades at this time. This is not the case with Karen's taillight. There is not a single known fact that is inconsistent with the much more plausible theory that the taillight pieces were there the whole time. The only reason to even consider a theory involving planting of the taillight is that you stubbornly assume that Reed is innocent and work backwards from the premise. And that's what they do. To use another scientific analogy, the FKR crowd reminds me a lot of the folks who, at the time of Copernicus, kept coming up with increasingly elaborate and convoluted models of the universe because they were so invested in the idea that the Earth was at the center of the universe. Copernicus tried to show them that there was actually a very simple model of the universe that explained all observations and evidence. You just had to jettison the idea that everything revolved around the Earth. But they didn't want to listen. So they just kept adding epicycles upon epicycles until their models were convoluted monstrosities that made sense to no one but them. And this is true. You can go and look at the models that were come up at that time by these people. They're really, really elaborate ways to try to see. Scientists could look, astronomers were looking at the sky and looking at the planets and trying and looking at their motions and trying to understand as they documented all that, how that could be explained by circling around the Earth, including the sun circling around the Earth. It didn't make sense. But they kept coming up with these crazy elaborate designs. But by simply recognizing that everything revolved around the sun, it cleared it all up with a very simple, elegant theory. But they didn't want to give it up. And that is how the Freecameron people are. Now, that's where the taillight planting theory is right now. First, it requires us to disregard pretty clear photographic evidence showing that Reed's taillight was fully broken well before any law enforcement was involved. So we showed this on the channel the other night. This is the dash cam video. The Canton police sent a cruiser to the house for a wellness check. Now, nobody was home, but this is what the dash cam from the vehicle got. And if you look on the left, you can see on the corner, it's nice and red. If you look on the right, it's clear. And we learned today from the rebuttal to the motion to dismiss that the prosecution has used experts to clarify this too. So what we see in the next trial should be even more clear than what we're seeing here. But it's pretty clear anyways. And we showed this one on the show the other night. So if you look at it, you see on the right, it's missing that outer taillight piece. And then if you look at what was taken, the picture taken in the Sally Port, it's exactly the same. It's exactly the same. And you could see where, so let's just stop for a moment and look at the one on the left. Now, this was earlier in the day, but Officer Barrios of the Dighton Police would have saw something similar, only even more snow would have been on top of it. So Karen arrived in Dighton at maybe around 1 o'clock, right? And parked it in the driveway. And Officer Barrios and the troopers got there around 4, maybe a little before 4. So there was substantial snow that would have accumulated on that, and they weren't allowed to touch it. Karen's brother, noticeably, when he cleared the Lexus in the driveway at One Meadows at John's house, he didn't touch the taillight. He knew it was broken. So when you take the glass off it, you have the housing on the underneath is exposed, and it's kind of like a cup. So if you take a cup and put it out on your porch during a snowstorm, it's going to fill with snow. So that taillight housing would have filled and packed with snow. But what Trooper Barrios described was what we see here. He wasn't going up and doing a drawing and taking notes. He just had to give a basic report. And he said the taillight, in his initial report was that the right taillight was damaged. That's all he said. When he testified on the stand, he said that most of the taillight was intact, but the right piece was missing. The right corner was missing pieces. Brother counsel falsely, the taillight was intact. No, that wasn't what he said. brother counsel. And, you're misleading your audience, and that should matter to you because you're a smart guy, and it's not worth adding a few thousand viewers to your audience just by spinning bullshit. Officer Barrios described what we see here. So let's continue. This suspension of disbelief will be even harder in the second trial, as the Commonwealth revealed today that they've generated high-quality, clarified photos of Reed's taillight that they plan to show to the jury that prove that the damage to the taillight was consistent across time. So we'll see how good they are. There's only so much you can do with improving a bad photo. You can't use AI because that's altering it, but you can just tweak the lighting and stuff like that. Second, in light of the various photos and eyewitness testimony, let me just check and make sure. All right. In light of the various photos and eyewitness testimony, believing the taillight planting theory also requires. Sorry, I read that poorly because I got distracted. All right. So second, in light of the various photos and eyewitness testimony, believing the taillight planting theory also requires that you believe Karen damaged her taillight in some other way. That's why the defense has insisted that the taillight was first broken when Karen backed the Lexus out of the garage the next morning and lightly tapped John's Traverse. That assertion was always dubious, given that it happened at such negligible speed and no pieces can be seen falling into the snow. But it's going to be completely untenable in the second trial when the prosecution presents expert evidence demonstrating conclusively that it's not possible. Finally, as I and others have explained previously, the timeline of the taillight planting theory just doesn't work. The vehicle pulled into the Canton Police Station Sallyport at 5:36 p.m. on the night of January 29th. By that time, the CERT team had been on site at 34 Fairview for almost an hour. Lieutenant O'Hara testified that the last member of the team arrived at 5:41 and that they'd already begun their search by that time. Even if you assume that Proctor had a ghost man, Turtle's ghost. This theory requires that Proctor immediately break off pieces of taillight, hand them to his nameless accomplice, have the accomplice whiz across town, and at best arrive as the CERT team has just begun their search. Unless you're going to posit that the CERT team and the other people at the scene were all in on the conspiracy, this accomplice would have to sneak into the search area and manage to bury the taillight pieces exactly by O'Keefe's missing shoe. So unless they buried the shoe too, right? Under 3 feet of plowed snow without anyone being the wiser. Again, so it's always been crazy. So now Turtle Boy struggling, realizing that this has been crazy, and I've been pointing it out to him for over a year, is now going to go with that an actual CERT team member was the ghost. And so all these people are in on it. Murder conspiracy, jeopardizing their career for someone they don't know. Again, I've always said one of my YCT rule number 7, I think it was, it's not about motive, it's about sufficient motive. Doesn't matter that your sister knew Chris Albert's wife's sister. Okay, so there's a connection there. Maybe that could get a speeding ticket fixed, right? But you need sufficient motive to show that Trooper Proctor is willing to risk his family's welfare, his freedom, his career to plant evidence. Plant evidence 16 hours after the crime. If at any part of the day, some clear video, or let's say Karen's brother he worked at a car dealership, maybe he goes down, maybe he takes a picture of the taillight. They don't know what the circumstances are at Karen's home. Maybe they could have taken that Lexus into a garage, and when it melted, taken clear pictures. It's not implausible that they did something like that. They would have done something like that. Trooper Proctor couldn't know. So extremely risky. So when people try to say, they just assume they're going to get away with it, that's insane. So if we're going to entertain this scenario, why wouldn't this person plant the rest of the taillight pieces in places the CERT team would find that night? Why break this planting/finding exercise up across multiple visits and multiple locations? And when did Proctor or this accomplice crush up the taillight pieces and plant them on O'Keefe's clothes? It's so absurd. It's so absurd. It's maddening to think that other human beings that are walking around and driving cars and voting believe this stuff. I mean, it's, I want to be respectful, but it's crazy. He continues, and while we're at it, can someone remind me why these guys would go to such elaborate and perilous lengths to frame an innocent woman? In the Birchmore case, which the defense loves to cite as a parallel, the dirty cops, and there was only one involved in the murder. There were other dirty cops that were not involved in the cover-up, but that had abused poor Sandra. The dirty cops did the things that they did to cover up their own crimes. So yes, so Matthew Farwell, alleged killer here, he's the one that tried to delete all the stuff on the phone. He's the only one that is known of in any way covering anything up. There's no evidence on file at this point that the state police in any way dirtied anything up in that investigation. Not yet. You can't just pretend that there was. So Farwell was covering up his own murder. So you can understand his motive. Again, sufficient motive. But what motive did Proctor and Buchanan and the ghostly CERT team member, what did they have? And as Anonymous points out, even Farwell didn't try to frame an innocent third party for the crime. Why would Proctor and Ghostman put their lives and careers in such obvious jeopardy in order to help Brian Albert, who, remember, Proctor didn't know Brian Albert, or whoever the culprit of the day is? None of this passes any kind of common sense filter. The undeniable reality here is that the taillight pieces were not planted. And it's a sad testament of the state. It's a sad testament to the state of discourse that so many people can't bring themselves to see that. I don't really know what else to call it, but agree that it's sad. It's sad that this many people. Oh, Daniel actually made it. Good. Hey, Daniel.
How's it going?
Oh, I got to put my headphones on. Sorry, brother. How long were you waiting? I couldn't see because I was reading the document.
Oh, no, just about a couple minutes. There's not too big deal.
Oh, okay, good. How's your arm doing?
A lot better today. We did the phone or the wound dress up thing, and the wound probably started off the size of maybe a little bit smaller than a softball. Right now, it's probably smaller than a golf ball that is open. Still have partially the artery exposed, but a significant amount of it less. So I would say probably about another 3 weeks before it's sealed up.
Man. And it has to be more surgery to repair ligaments or anything like that, or skin grafts, or
I don't know yet. I got another doctor's appointment in another week or so. They're going to just tell me if I'm going to get a skin graft or not. And I have an appointment coming up where they're going to do this electric thing in my arm to determine to see if the nerves are still working or not. And so I got all those things that I got to go through. I would say that I have some nerve damage just because movement in my left hand is probably like at 30% at best. I would say I can use it more like a claw than I can a hand, because I can squeeze with my thumb, but it doesn't bend, and those type of things. So it's I can move my fingers a little bit. My up and down motion of my hand is where I lack the most mobility.
And is that your hand? The hand you use? Are you left-handed or right-handed?
I'm right-handed. Fortunately, it's my left hand, but it's still, you would be surprised how much you use your left hand. I know I am, and it's frustrating. Yeah. There's so many things that I would normally do, and then sometimes things happen out of reaction. I got up today and the pillow kind of fell off of my arm, and I have a quick reaction time, so I normally would just catch it, and I try to do it with my bad hand, not thinking about it. And I had to sit down for a second. After trying to do that. And I actually did that twice today, and I got to sit down. I got to slow down. I'm going to go to so
Is it in the shorts, the one you have a video analysis that I've been told is really good of the tail light? Is that in your shorts or is it in regular videos?
I think that one's a
What's
regular video. Well, you know what? I
regular
might
video?
have a short of that one as well, but you know,
Oh,
let me,
yeah, either way is fine.
yeah, let me look. I,
I'm looking
I,
through. I'm look.
it would be one
Yeah,
of the more recent ones. I know I had one on TikTok that was a short that I had done about the tail light.
I don't even know if I can get into TikTok. I did some videos on TikTok and they suspended my account. I didn't violate anything. I think Total Riders just must have all been complaining, and they didn't give me a reason. It's just suspended. And the only thing I ever did on it was Karen Reed videos, and I did maybe, I don't know, 6 or 7 or something like that, maybe 10.
Yeah. Yeah, it wasn't a short, it was a video. And let me see. It was the video that I did a while. It was probably right before we started talking.
So was it a whole show that you included this in? I'm going to link to it. I just want to find it.
I'm gonna see if I can get it for you real quick.
Okay.
Yeah, because I know I did a all right here. It's called Proof This Doesn't Look Good, Proof in Plain Sight. It was about 2 months ago, and it is about 9 minutes and 16 seconds long.
Okay.
And no, I don't have the wound back anymore. The depth has gone down, so it's at 0.02, whatever that means. But apparently the depth is low enough that they don't need the wound vac no more, which is a positive thing because that thing was as traumatic as as the bite itself.
Yeah, and then the nerve will probably grow. But nerve growth is slow, so it'll take a little more time for that.
Yeah. And on this video here, that I had broken it down. The only thing that I had added on early on was because I couldn't tell if John O'Keefe's vehicle had gotten struck or not. And so I had put on there, I was like, I can't tell. But even if it did, you don't see any tail eye pieces underneath of it after she leaves. And you can
that's the main thing. Yep.
You can clearly see a big part of her tail light is missing. And I show it before, after. I show how the breakdown as it drives away. I show the vehicle driving away. To me, there's no way, and this is absolute 100% proof that she hit him. And the reason being is because she's parked in a garage. That means that the vehicle is safe from the elements. The vehicle is safe from any plows or vehicles or anything else that she may have considered that she thought hit John O'Keefe. And it's also protected from the evil, Trooper Proctor, and he can't get to it there. And plus, this is before John O'Keefe's body is even found. So if you have the missing tail eye pieces and you have the pieces found there at where the body is located, and you can see that it's missing here already, that just tells you that before John O'Keefe's body was found, that her vehicle had the damage, and that the pieces from that was found where his body was located. There's absolutely no other explanation. She left directly from his place. Now, unless she had damage to the tail light beforehand, but even if that ended up being the case, where would Proctor and all of them have gotten the tail light pieces from an accident prior to John O'Keefe's the accident that may have struck John O'Keefe? You know what I'm saying? Like those worlds don't exist together.
Right. So you'd have to go with the idea that Proctor busted an undamaged taillight in order to break it. Or something weird like that. Every road you go down is kind of absurd. I also, to point out too, and this could be thrown off a little bit by the wind. It was a blizzard with high wind. But if you look at the snow in the driveway, it's a little hard to know exactly how much there is. But this is at 5:08 in the morning, and this looks like I don't even think it could be more than 2 inches of snow, but there is a little bit of snow, maybe more on John's Traverse. So maybe some of the snow in the driveway had blown around a little bit. But I don't know, how much snow would you say that is? Is it more than 2 inches, or?
I would say close to the house would probably be less than 2 inches. You can see where the snow is picked up. Now, depending on the direction of the snow, if the snow is coming from the opposite side of the house, there's a good chance that the house may be protecting about 4 or 5 feet of heavy snow, depending on which direction it's heading. But
Right.
even if you look at the wheel there, it would not be more than because you can see the bottom of the wheel, the tire. And so the
Yeah.
tire's what, like maybe 2.5 inches thick, maybe 3 inches tops, and you can still see the bottom of the wheel. There's still a little bit of black there on John O'Keefe's
Right.
vehicle. So I would assume somewhere between 3 to 2 inches of snow.
So the reason it matters is because Lucky Lawford testified that he made several sweeps starting at 2:30 and then again at 3:30. Now, I've talked to several plow people and they all say, and actually, the guy from the DPW testified similar on the stand, that you generally don't start plowing until you have 2 inches of snow. There's a little bit of wiggle room there, and it's in the judgment of the plower. But it just seems hard to believe that if there's this much, it's snowing hard here too, that if there's this much snow at 5:08, it probably started snowing hard sometime around 4. I don't think there was more than a dusting at 2:30, but I have not been able to prove that. I'm not in all implying that Lucky lied. Just think he could have been misled, could have been manipulated.
And you know, when it comes to memory's tricky. Witness
Yeah.
testimony is not high on the list of reliability for a reason. And that's mainly because if you're not anticipating to remember something, you typically don't. And if you're trying to remember things, and then especially if there is talk in the air, or if there's conversation or things that he's may or may not have heard from other people, those things may end up filling in the blanks, so to speak, of what he may or may not remember. And that's why witness testimony is horrible. In the Richard Allen case, I think there's a clear just depiction of how bad witness testimony can be. There was 3 juveniles that were walking out of the park at the same time as he was walking in, and all 3 described the same man differently.
Yeah.
As far as
It's true.
height, weight, what they were wearing, color of clothing, but they described the same event as that one of them said hello, and then the guy just walked by them, just blew by them. And so they were right next to him. A horrible crime happened the very next day, and they were asked to remember what had occurred. And that was the information that they had gotten. And so witness testimony is not highly reliable. Even if, the only testimony that I could say that could be reliable as far as witness testimony, and that's it just depends on the time, right? Now, if it's something that is happening to somebody at the time of the incident, like, so if you're asking a witness to remember, or a victim to remember something that's happening to them, that's a completely different situation. You know what I'm saying? Or if the witness is completely aware of the fact that they need to recall this information. So if they're seeing something in progress, that's a different story versus something they had no idea they needed.
Right. And even then it's a problem. Famously, if 10 people witness an accident, you're going to have 10 different accounts. And I was just talking to someone the other day that she was relating how when she was 17, a store that she was worked at was robbed by a guy with a knife. And so then she had 2 other coworkers. So the 3 of them had to go to the police station to give their report. And once they got to the police station and each gave their reports, they realized they all had described a completely different person, So and that was something that they were trying to remember, right? Or at least had some moment, they had a reason to remember it when it happened. So yeah, human memory I'm not good at remembering faces and clothing and stuff like that. I'm really good at remembering events and sequences, narratives, and that kind of thing. So I will, but yeah, it's very, very imperfect. And Lucky Lawford is a little bit special needs, and he would have been nervous when he was talking to a private investigator that's a retired cop. And so the first person that Lucky spoke with was Karen Reed's investigator. And so that really opens up the door to some form of manipulation. I'm not accusing anybody. I'm just saying you have to at least factor it in a little bit.
Yeah, I thought I read something that said something to the effect that he got some times wrong, and there was proof of these times being wrong, and that was to show that all the other times that may have been a question mark. Something about when I think he said that he saw law enforcement out there at a specific time, and at that time would have been before
Yeah.
his body was found or something of that nature, that he's seen the first responders there. Wasn't there something
Yeah.
of that nature?
Yeah. So in the trial, he testified that he took David Yannetti, the defense counsel, by surprise. Counsel asked him, when was the last time you plowed it? And Yannetti thought he was going to say 6:30 because he had previously said something like that. But 6:30 didn't make sense because that whole street would have been blocked off till 8 or 8:30. And so what he said was 5:30. And as soon as he did it, I was in chat like, please, prosecutor, jump over this, because if he's telling the truth, if he's being accurate, that means he didn't see John at 5:30 either.
Mhm.
So that means John was pretty well obscured in the way he was.
Yeah.
But the prosecutor unfortunately didn't pick up on my chats. he wasn't watching during the trial. But yeah, so there were some problems with his memory.
Yeah. And there's just so much more also in this case outside of just the taillight that makes you look towards Karen Reed. I mean, the constant change in the story that she had, the fact that when even the fact that she said, because I've said this a couple of times, there's three things that you need to look at as far as behaviors go, and it's behavior during the crime, and then afterwards. And all three of them, there is some pretty there's some evidence that is leaning towards her. And the evidence during the crime is obviously she was out, she was available, she was at means, motive, opportunity, she was there. And the other thing is also she had like when she went to go look for him, instead of going back to the direct spot that she thought that she saw where she saw him last, she went everywhere else. She didn't go to the Albert's house directly. She went, I think it wasn't until after she went to Jen McCabe's and the other witnesses, they all got together before she went back there. Isn't that correct?
Yeah. Right.
Because in her interview, because her interview says that when she left, that she got a phone call from Jen, and they said that Karen and John never went into the building.
Right.
And so that she left, and then she went looking for John and all the other places that they were at, and then she met up with McCabe and the other witness. I can't remember her name.
Right.
And then they went back
Terry
to John's
Robbins,
house, and then they went to John O'Keefe's house. The problem with that story is, if she was going to go back to retrace her footsteps with him, the first step would have been the Albert's house.
Mm-hmm.
Now, is there evidence that shows that she didn't go there first?
So the state believes she returned to the scene of the crime. They were not able. They at this point, unless there's new data with the new vehicle data, they can't prove it. So what they have is her heading in the general direction of that area, and then there's a little bit of a time gap. So she ended up at the McCabe house, I think 20 minutes later, or maybe 15 minutes later. So it gave her time, but it in no way proves that she went down that street. Certainly doesn't prove that she saw John.
Right.
So barring any new evidence, we really will never know for sure.
Right. But I mean, by the time that they found him, it was snowing heavily at that point, right?
Yes.
And he was in a place that you don't normally look for, and not very well lit, correct?
And he was covered in snow, because when they did find him a half hour later, the three of the women together, Kerry Roberts testified that even when Karen jumped out of the car and was running to him, she didn't understand. She thought all she could see was a mound of snow. So there actually, Daniel, there was something interesting that came out yesterday or a couple of days ago in Karen's interview. She's revealed a new detail. I want to hear what you think about this.
Okay.
And we'll keep the tail up because we'll come back to it. But she says that the day after John's death, her lawyer told her to hire a private investigator and retrace her steps. So she describes going back to John's house. She doesn't say where else she went, but if she retraced her steps, presumably she went back to the scene of the crime too. So what do you think about that? Is that normal? Is that, why would she? And also, let me just add to this too. So John died on a Saturday. This private investigator thing, if she's telling the truth, was on a Sunday. Karen, she was arrested on a Tuesday, spent the night in jail, and arraigned on Wednesday. And she met her lawyer for the first time in person Wednesday through the prison bars. And then in court, he did not say like the standard answer that a defense lawyer will say in that situation and say, my client is innocent and we look forward to our day in court. That's like the standard answer, right? And if you end up pleading later, who cares? he said my client had no criminal intent. He said that in court, and then he said it moments later on the courthouse steps to the media.
Right. No, I
So
remember that.
if there's any excuse me, if there's any way at all, if Karen even said, I don't think I did this, Mr. Yannetti. I remember seeing John go in the house, or I don't think I did. If she even hinted at that, her lawyer would have said that my client didn't do this, but that's not what he said. But yet, you got this supposed step retracing on Sunday. So what could have been the purpose of that step retracing from your experience?
She was blackout drunk. She don't remember where she was.
But why would the attorney tell her that? You know what I'm saying? I think she's trying to say this.
Because if she doesn't know, in order to come up with something, she needs to know where she was at. In order to fabricate something, you need to know what the evidence is against you. If she doesn't remember where she was at and how she can make up a story with it, that's going to be a huge problem. And, that's probably a reason why they said she probably thought she hit him too.
But the thing is I don't think that she was trying to fabricate anything at that early time, because if they were, she would have said, again, they would have said in court Wednesday that my client didn't do this.
That's true.
So up to that. So what we know is David Yannetti's version of it, this murky kind of private investigator guy named Steve Scalin, reached out to Karen in social media, maybe Tuesday morning on Facebook. And we don't know exactly what he said, but he offered his services, and she said, reach out to my lawyer. So he leaves a message, according to David Yannetti, he leaves a message under a pseudonym on Yannetti's phone.
Mm-hmm.
Yannetti doesn't call him back, though, until after the arraignment, on the way home from the arraignment. And it's in that call that this guy first tells him that he has information or believes that John was killed inside the house. So that's the beginning in their minds of even a possibility that Karen didn't do this. Up to that moment, they don't even seem to have entertained the possibility that someone else could have done it. So what could she, so I'm not sure if there's just some routine thing. I don't know if you're not trying to figure out a possible alternative theory to the crime, why would she have to be retracing her steps that Sunday? That's what I can't figure out. But I thought maybe you might have some insight into that.
I mean, she, like I said, the only thing I can think of is she may want to retrace her steps. She may not have known. She may have thought that she did hit him, and may have thought
she did.
Right. And thought that was the case. Like, I did hit him. But maybe there was a moment where she's like, I don't remember everything that happened that night. Moments of that night may have been blacked out, and trying to remember and follow through with those. I mean, if she's over 0.2 or a 0.8 at 9 a.m. in the morning, geez, I mean, that tells you she was probably close to 0.2 at the time of the accident, maybe even higher than that, maybe even a lot higher than that. I would suspect that somebody that intoxicated may have some moments where they don't remember things. And, I think that may have been some of what she was trying to do, is backtrace where she was at, because, if she's going to defend herself, she needs to know where she was at. Now, that doesn't necessarily mean that she, at that moment, her defense was going to be, somebody else committed the crime. Her defense may have been, I had no intent on, there was no intent there. There was nothing.
Right.
And they were trying to disprove something there, but it's interesting.
Did you have any hit and run cases in your time?
Oh yeah. Several.
Yeah. Is it possible that a defense attorney will, just as a matter of routine, in every hit and run case, say, go retrace your steps, because maybe it becomes useful later? Is that just routine? Maybe is that possible? I don't know.
What do you mean? Run that by what is routine?
Is it possible that a lawyer in every hit and run case will just tell, whatever the circumstances are, just tell their client, go get a private investigator and retrace your steps? Just as a matter of routine. I'm trying to guess, because I don't understand. I don't know. First of all, it's possible Karen is just making this up. It's Karen. She makes up a lot of stuff.
Right.
But if she,
I don't see the advantage. What would be the advantage of that?
I don't know. Oh, of making it up?
No. Of
doing
saying that she had her steps retraced.
Well, the advantage is she's. I've brought up many times on this channel, and she does watch, that Karen had no notion of being innocent of the crime until after that Steve Scanlon talked to her lawyer.
Mhm.
So by the time of her arraignment, she wasn't even entertaining the possibility. Now, that sounds kind of weird now to her when you're trying to sell this story of you seeing John walk into the house. So her story has evolved over time, where initially not seeing it to now that she's seeing it. But that's the obvious question. What the people would say is, well, people that believe her would say, if you saw John walk in the house, then why did you just accept the state's theory on this so quickly? Why didn't you challenge? Why were you at the scene even thinking maybe you hit him? Because she's, multiple first responders testified to her saying, I hit him.
Yeah.
So she has said that in reality, she was asking that as a question. But why would you even be asking that as a question if you saw John go in the house? So I think that her trying to suggest that she went out the next day with a private investigator is just consistent with her narrative of, I've been trying to solve the case of what happened here since day one.
Yeah, I mean, that would be about the most that she's claimed to have done to try to actually solve it if it wasn't, her. Because, when you go and look at all her interviews and stuff, she doesn't really talk very well or in good light of John O'Keefe. Even the most recent one, when they asked her something about what do you think when you think about him, and she basically said what she said before to John's brother, just the bad times, all these negative things that are happening. Everything that's going on in her life now. When she thinks of John, she doesn't remember any of the good stuff or whatever. And so all those type of, comments and stuff like that are pretty consistent with somebody who has zero remorse for the actions of their own. But
you're doing a good job on, I'm just sorry, just pause you where you just zeroed in there is a good job on, let's replay that, of matching what was seen in the Sally report.
Yeah. So right here in this video, I was showing people was like, look, everybody's looking over here at this corner part. And I get it. It looks weird, from this angle. I can't tell if that red part is going all the way down the tail light or not, but there is some redness to the side of the tail light.
Right.
But what's clearly missing is the interior part of that tail light, the part that's closest to the tailgate, which is when I showed what the was found at, what the body was found at, that piece was found early on, and that's the piece that's right there that's missing.
Right.
So it's missing already before John's body's found, before anybody could break her tail light, take it, do any of those things. It's already gone.
Yeah.
It's not there. So it's impossible for somebody to have planted that.
Right. Exactly. And something that is in discovery that I've talked about, but was never played in the trial. I don't know if we played in this trial, but Karen did an audio interview in the summer of 2023, so a year and a half after this crime, when she told the reporter, and in the presence of all three of her lawyers, that she examined the taillight in the driveway when she was with Kerry and Jen, so around 5:30 a.m., and that she described vividly how it's missing pieces and there's wires exposed and blah, 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 and that she plucked a piece of taillight off and dropped it in the driveway. Now, the reason she told that story was because, well, obviously she hadn't understood at that point, that none of her lawyers did either, strangely, that they would ultimately want to try to show that the taillight was just cracked. They hadn't figured that out yet. But what they did want to the reason she told that story was to try to suggest the state police lied when they searched the property a few days later and said they didn't find any pieces. So she's like, well, there had to be a piece because I dropped a piece there. But that driveway was extensively, and Adam Liley did show this, the prosecutor, in the trial, even though they decided never to play it. But he snowblowed, the driveway was heavily snowblowed and shoveled and stuff like that. So that piece probably, we don't know how big it was. So we don't know what's missing from when you look at this, zooming in on your video here, but there could be a little piece. So it might be not exactly the same, even if this was clear to what is seen in the Sally report later, because there might be a little piece that she plucked off.
The problem is the piece that is, so the piece that goes down to the corner part, right? The very small end of the right side of the corner part, that's a big piece that's missing. That piece extends, and it's when you go and look at the reconstruction of the taillight, it's still connected. And so it would have gone all the way across.
Right.
It would have covered part of this middle piece that's missing. And
Yeah.
it's not there. It's not there. And so that's why I think that this redness here on the side there is an illusion based off of the camera angle. I think that it appears to be going all the way down, but it's not.
Well,
As like if you were to stop it right there, and
it's paused right now. But do you want me to move it to another spot, or
move it to that spot there?
To
where it's at?
Do you want to see the tail light in the garage?
Yeah.
Like that. There you
right
go.
there.
Okay.
So like from right there, that angle going downward, that line, I believe, reflects out red. That's in the clear area, and a lot of people are looking at this line that's clear, that's going all the way down, as an indicator that that somebody did something nefarious, that they plucked it, because you can kind of see this entire side marker light up red. But I think that interior light is already red, just like a lot of these interior lights are already red as well when they light up. See if you go back a little bit more to where the broken glasses pieces are. See right there, it looks like it's there. Let's see.
You look at the actual pieces like this here.
That one.
Okay.
All right. So that piece that where the fins are, that's a smaller piece actually.
Another thing to keep in mind, I don't know if this affects thing or not, but Ring night vision, it records in infrared, and then it has an algorithm that adds color. So it might not be looking at accurate when we see something that's red or not red.
That's true. But yeah, that piece that I was referring to that's missing. See, what I'm looking at is the inside, the right side of the tail light, and that's the piece that's found out on the ground. Well, that piece is right there underneath the reverse light, so that's closest to the tailgate. It's not near the opposite end where the fins are. Those fins are a clear indication of what is on the outside, and which last time when we spoke and you were on my channel, you mentioned that those look kind of very similar to the distance wise that you would on some of the wounds for John O'Keefe's arm. I think you're accurate on that. And so, but yeah, like from right here, it looks like it's there. Like I would have thought it was there, the red area, but I think it's an illusion. I think it's an illusion because of the angle that you're looking down upon. And also that reflective area, I think it lights up red.
Right.
Because it's clearly like the rest of it's missing, like regardless of anything. And there's nothing there. There's nothing in the snow there when she's backing out. And you can see that it's missing there. Yeah.
And so we learned today too. So we knew that they've done experiments over the last year after the trial where they took the John's Traverse from here that's still owned by the family, brought it to the state police garage, and tested it to see if this damage could have been caused by it in theory. And also we learned today that they had an accident reconstructionist that they've hired now, did testing and showed that it could not have at that speed. So, and really this is also what the ARCA guys, people lose that, but they also said that too, that when they were showing that video at that low speed, it could not have caused that damage.
Right. Yeah, I mean, like I said, this is before the body was found. This is before anybody knew of a crime. There's pieces of that tail light missing.
Yeah.
And that those pieces that are missing are found where John O'Keefe's body was found.
Right.
I mean, those are just undeniable facts. That that's there. It's missing, and those pieces were found elsewhere. And I think somebody had said something a little bit. I saw something in the comment section I'd wanted to highlight. What was it? Somebody said that it could have been snow. The thing is, the vehicle was inside of the garage, so it wasn't open to snow or to the elements. So no, it could not have been snow covering up that specific part of the taillight, and only that taillight.
Right. Unless you wanted to theorize that it somehow came onto the car when it backed into the Traverse. It touched it enough to attach some snow to it or something.
Yeah, no, there's no way. It's impossible.
Yeah.
Impossible. It's broken. I mean, you can see it's broken, and it's
Yep.
broken off. There's pieces missing. Like at the end of the day, we can argue left and right, but it's broken.
Yep. Oh, looks like I got to the end of your other video. Yeah. No, that was that was a good job. So, let me just quickly say thank you to people. So, Darlene gifted 5 Yellow Cottage Tales memberships. Thank you very much, Darlene. And Claire is always one of our biggest supporters. Thank you very much, Claire Murray Stewart. Nancy from the 508. I used to be from the 508 too. Thank you very much, Nancy. And Tully, super sticker. Thank you. Totally appreciate it. Robert Parrish. I'm sure it's not Robert Parrish, but Robert P's a regular. But I grew up Celtic fan. Robert Parrish was the center, the chief. Funny Bunny, thank you very much. She has a question. Did Proctor ever go to the site the same night? No. Neither Proctor nor Buchanan went to the crime scene that day. What do you think about that? That's a really good starting point, Funny Bunny. Let me ask this to Daniel, who's former law enforcement. So the troopers never went to the crime scene that day. What do you think about that? Is that suspicious?
No, because I don't. Did they? One, was it supposed to be a trooper case? I think it was supposed to be Canton Police who decided later that they weren't going to do it. Right. So that's the first hurdle is jurisdiction. And so if it was supposed to be Canton Police and Canton Police decided to exclude themselves from it because of connections to the Alberts or to John O'Keefe or whoever it may be, then that would be one of the main reasons why they didn't show up right away. They didn't know they were supposed to show up right away. That those decisions need to be made first. And I believe that decision wasn't made till the next day. So right off the bat, that expose or debunks any kind of theory of why they didn't show up right away. The other thing is, when was it considered a hit and run scene or a hit and run that was going to be considered like that they needed to preserve? You know what I mean?
All right, let me run. Actually, this is good that I have you here. Let me run through the sequence of the day and see if any of this sounds inconsistent or the way you would not want to see things done. So the first stop for I'm just from the troopers side. The first stop for the troopers was at the Canton Police Station at 9:30, and they were there to get the first accounts from the Canton Police as to what was happening. Now, at this time, the crime scene is unprotected. They had tried to tape it off, but that proved to be futile in a blizzard. And they should have left. The Canton Police should have left a police car there, but they didn't. So the crime scene was just a snowy yard at that point. The victim was long gone. So they took statements from the police at 9:30. Then their next stop was to go to the McCabe's house. So Jen and Matt McCabe had been at the waterfall and had been at 34 Fairview during the after hours party. In addition, Brian Albert, who the homeowner from 34, met them there. Now, it made sense that they would go to the McCabe's because they had young kids at home. The Alberts did not. So while at the McCabe's, the troopers interviewed, and they separated them but they interviewed Matt and Jen and Brian Albert. Now then, I'm not sure what time exactly that finished, but say around 11:30. From there, they went to the hospital. Now, to me, I've always been, this is both, on the one hand, a little bit troubling, but on the other hand, it proves that they were not part of a conspiracy. The murder weapon was sitting a mile away, and they didn't go to secure it. But I don't think at that time, even though they hit and run must have been in their minds, because by then the witnesses were starting to go in that direction. But for whatever reason, they didn't go secure that vehicle. They went to the hospital. Now, they believe the defendant was at the hospital at that point. But at the hospital, they could view the victim, gather evidence. So when they got there, they found out that Karen had actually left. And so they looked at the body, talked to emergency room staff, and gathered the clothing. Now, at that point, that's when they realized there was a missing shoe. So that was the really kind of first solid indicator that it was probably a hit and run. So from there, they went to Karen's house, but she had taken the vehicle, and her parents lived about an hour away. She had taken the vehicle to her parents' house. So they arrive at her house at around 3:30, and they interview Karen, and they tow the vehicle back to the Canton Police Station, Sallyport. It arrives at about 5:30, a little after that, and that's pretty much the extent of their investigating for that day. I think they were at the Sallyport till about 7. Now, they had evidence there of the broken cocktail glass had been collected by the Canton police earlier. So they had that. They had the blood that had been collected in the party cups, which turned out to be useless. So they just got rid of that. And now at this point, they already had John's clothing from the hospital. So around roughly 7:00, they left the Canton police and went to the DA's office where the evidence room was, and they put away the evidence. So that was their day. So they never went to 34 Fairview. The CERT team, the special emergency response team that found the taillight pieces, they started arriving around 5. They started digging in earnest around 5:30, and they found the main taillight piece at 5:45, and they were all done by 6:22. So
somebody did go. It just wasn't them.
It just wasn't them, right? Yeah.
All right. Well, first things first, officer safety is most important. So if you have yourself a blizzard and you don't have proper tools and stuff to keep the officer safe out there in the elements, you know, you're going to do what you got to do that. So basically, because there was the elements aspect to it, the fact that there wasn't somebody out there or that they left it, I think that plays a huge role.
Yeah.
Everything else that you had mentioned. See, I wrote a couple of things down. They did the interview at somebody else's home. That doesn't seem odd. I mean, these weren't suspects. These were witnesses. So I don't understand why that would be anything too nefarious or looked at wrongly.
Right.
Then they went to the hospital instead of securing the vehicle.
Yeah. What do you think about that?
Well, you do need to get probable cause. And even if you go out there and you see the vehicle damaged, that doesn't necessarily mean that it was damaged from there. So you need to get probable cause for it. Probably your best bet is to get some statements, get her to say that she drove the car, that she was driving the car that night, and that, those type of things, some bare minimum stuff. So that might be one of the reasons why they went first there. As far as going there at 3:00, man, I probably would have gone earlier. Because destroying evidence is something that can happen if somebody has access to their car. They should have easily cleaned off a lot of that DNA that was found on that vehicle.
Yeah, there could have been blood in the car. There could have been empty beer cans. I mean, typical things you might find in a hit and run, right? So,
and I don't really think it makes too much of a difference if the lead investigator ever goes out to the scene to collect evidence. That's not his job. You know what I mean? The scene would have already been completely
processed,
not necessarily processed, but it's no longer the same as it was when the crime occurred, much less when the body was found or anything like that, based on the elements and everything else. I mean, you're going to want to go out there eventually. There's some things you're going to want to look at, the distance between where the body was to the residence and a few other things. But the fact that they didn't get out there to the next day and people are concerned that they didn't check the house. I mean, one, you need a warrant for it, which would require, reasoning to go in there and look. What would be the reasoning? Somebody's body was found because it appeared they got hit by a car at the corner of your property. That's not enough reason to go into somebody's house. Right. You know what I mean? Now, could they have asked? I guess, but that's officer discretion, at that point.
I think one of the things too, maybe you could speak about this, is that we in the public have some misconceptions based on our knowledge of these investigations are from watching Columbo. And, so we think that an investigation into a murder or a big crime or something like that is gumshoes going out and solving the case. But I think it's more routine, it feels like, right? It's very compartmentalized. So you have the cards team would come in and go over the car for evidence. And you have various, you have the data guys. You have, obviously it's just all compartmentalized. You have the evidence recovery teams that go to the crime scene and document where the pieces were found and stuff like that. And they're just kind of, the troopers are the lead investigators, but they're really just coordinating the whole process. They're not actually like Columbo going out there trying to figure out every little thing that happened. They're going through talk about that.
I mean, it depends on the scene that you have, right? So, this scene here is a little bit different because this is a traffic accident, fatality. And so typically, like, if this was the department that I was in, traffic would have taken care of it. They would have gone out there. Now they would have gotten homicide involved as well once they would have figured out, what was going on a little bit, but that would have been a lot further into the process. So there would have been a handing off of that there. But if this was like a robbery or an in-home thing or an assault or something of that nature, you have your lead detective. He's going to go in there. He's going to look around. He's got a lot of training under their belt, in blood splatter and a bunch of other things. Now they're not the experts. They know enough. I mean, think of them as like the emergency doctor, and then referring up to, the specialist when it comes to like blood patterns, blood pattern specialists and things of that nature. Right. So their job is to find the right things and get it to the right people. And in this scenario here, it's a tricky one because you have a lot of different things that are going on. You have the elements, you have the fact that it could have been just a hit and run. Then there's the aspect where it changed into there's intent behind it, right? So that's homicide, that's murder.
Right.
That would be completely different because traffic investigators, they investigate fatality accidents, even if it's a DWI fatality accident, hit and run fatality accident. That is not something that would go up to a detective. Right. You know what I mean? The only time that it would go up to detective is all of a sudden they found intent behind it. Now you need to get a detective to come in here and pursue warrants and get things for cell phones and for homes and background checks and et cetera, et cetera. And so that's where that is divided or different. So in this scenario here, it's all right. When was it changed that it was more serious than a hit and run, that there may have been intent behind there?
Well, it may work a little different in this state. So in our state, and again, I didn't know this really until this case either, but any unattended death is going to, if it's required, an investigation is to be headed by the state police, with the exception of the three biggest cities in Massachusetts, Worcester, Boston, and Springfield. They have their own homicide departments to take care of that. But any unattended death, so we're going to investigate this no matter what. They lead these investigations in cooperation with the local town police. In this case, the town police were excused from it because of Kevin Albert being a detective on the Canton Police. So I just want to say quickly, Macy, thank you very much. That is way more than I deserve, trust me. But thank you. I appreciate your generosity. She says, thank you for all your hard work and preparing and explaining to us. You're greatly appreciated. I look forward to your shows, even though they're great for putting people to sleep. But if that's my service, that's fine too. And just one more. Caroline from Canada says, great job, guys. Thank you very much, Caroline. You know how much I always appreciate your support. Thank you. Okay.
Yeah, so that's completely different than what we do down here. Completely different. The only time we call in a different agency is if there's some pretty crazy circumstances that are involved for them to take over like that. We even in the department that I worked in, which was not one of these metro big places or big cities, outside of a big city, but not the big city, we had our own homicide division. We took care of it ourselves, and we had several different divisions that took care of things. Ours, traffic would have taken care of something like this all the way through, unless once they found out that there was intent. That's when it would have changed for us. Our homicide would have got involved. Any unattended deaths, Okay, so then then you would have thought the process would have gone forward from that point, as far as, all right, there's somebody who passed away and their life was taken from them. It wasn't natural causes, so to speak. Um
Mhm.
so it was always gonna, but how long does that process typically take from that transfer, from when there's a death to the point where there's a trooper assigned? I
It's
can't
gonna it's gonna
imagine that's
it's
immediate.
it's gonna be that day. Yeah. So here it was any unattended death. So even if just, for example, this is different state, obviously, but the Gene Hackman,
Right.
those were two guys that were unattended deaths. So it's automatic. So it could be a suicide. Um, it could ultimately turn out to be just death of natural causes or an accident or something like that. But any unattended death, the state troopers have to lead the investigation. So they're assigned to the detectives unit for that particular county. So this
Mhm.
is part of what I had to learn in this case too. So, in my incorrect imagination, I would have thought that if the troopers are running an investigation, that their office is inside a state police barracks. Not the case. In
Mhm.
Massachusetts, there are troopers that are assigned to every county, and so they are part of the detectives unit for that county. In this county here, Norfolk County, which there's several substantial cities there, um, because it's a suburb of Boston. There were only 4 at the time detectives assigned to the county. Now there are there's their bosses and there's other specialists that are
Right.
assigned to it too. But their offices, they report every morning to the Norfolk County DA's office. So they don't report to work at a barracks. And the evidence room that they bring the evidence to, not surprisingly, is at the Norfolk County, is at the DA's office, where the prosecutors have access to it. It makes perfect sense. Just I never would have thought about it before this case. So what's you said you worked in? Tell us more about where you worked. Was it in a suburb? What's it? Can you say what city it was a suburb of? Or
I was outside of San Antonio, but the we had we had what, 4 shifts, 12 officers there each shift, plus supervisors, detective unit, traffic division, SWAT division. I was part of there too. Probably employed about 130 officers for our area.
oh, oh, it's
And
pretty
so,
big. Yeah,
yeah, we were pretty large.
yeah,
We weren't small. We weren't San Antonio, though. That is several
right.
subdivisions and stuff like that. But yeah, when we had a situation like that, that's how ours would work. Doing it this way is Massachusetts that's confusing. You just blew my mind talking about how you have to do it. Now, if you have a scene, I reckon it's pretty quick though. You're probably just calling one person to another. But in
Yeah.
this scenario here, given the elements and stuff, I mean, is there a notification of when Proctor was even notified, as far as that there was
Yep.
a
Yeah,
death?
he testified in court, so he was on schedule, on a schedule that had been made a month before. He was called just before 7, and had this call come in after 7, he was off. So he had almost made it to the end of his shift when he was on call at home.
Yeah.
Um, and obviously it was added difficulty because of the blizzard and traveling around and stuff like that. Because of the blizzard, they got authority to use their own personal vehicles. So each one of them had a truck or an SUV. Trooper Buchanan met Trooper Proctor at the Canton Police Station, their first stop around 9:30. And for the rest of the day, they used Trooper Buchanan's truck. He had a larger truck, but also that freed Proctor to make the calls. For
Right.
instance, arranging a tow truck, arranging a plow, whatever else. It's all management of the various things that are going on.
None of that sounds out of ordinary.
Yeah,
None of the things you say have like, none of the stuff you've told me sounds out of ordinary.
right,
Like, I
right.
like, nothing seems like, oh no, they should have done this differently.
Yeah.
Like, even like some of these things that people are upset about, like, I don't understand why they're upset about it. Oh, like Proctor had access to the car. He's a lead detective. He's gonna have access to the car.
I know.
What are you
There he
talking
is
about?
standing behind the taillight.
Yeah, that, and like the new stuff that just came out. I guess apparently they have him on the phone. What would he do? Do they? What's bad about him being on the phone behind the police station? I don't
That was actually not him. That was Agent Higgins, who
really.
was drinking with them that night. And so this was another one of the things that were presented as odd, right? So when the story
Yeah,
first was presented to us, and a federal officer is at the party, and then strangely, he reports to work at 1:30 a.m. at the Canton police station. It does sound strange, right? Until you get the explanation. And the explanation is because he's a federal agent and he does undercover work and different things like that, he had permission to store multiple vehicles,
Hmm.
basically federal vehicles at the station. But during a blizzard, during a snowstorm, those vehicles have to be moved to the back of the parking lot for plow, so the parking lot can be plowed. Now, he had just returned that day. Him and Brian Albert and Kevin Albert and another cop had gone to New York City, which
Right.
is like about 5-hour drive from here, for a funeral. There were a couple of cops that have been killed in the line of duty. So then he comes back, and now that they're hearing about the snow, he left the keys on the desk, but somebody else, if he's gone, has to go and do that. No, he intended to be gone, but they came back a day early, and so nobody else would have to do that work for him. He drove to the Canton police station to do it. So he got there, he moved the vehicles around. He had to go move the keys. He had to go into the station to get the keys, I guess. And when he came out, the video surveillance shows him on the phone. We have no idea who he called. Who cares? It's none of our business. He was checking his messages. He was calling a booty call. He was calling in Domino's Pizza. I don't know. It's a private thing. It's none of our business. But the feds have his communications. They know who he called, 100% with certainty.
Mhm.
We know that they have his. So, and at the federal grand jury, which the defense has access to all those minutes, the feds didn't bring it up. So if he had called, for instance, Brian Albert at that time, the feds would have brought it up. So whoever he did call, the feds didn't find it suspicious, and they were trying to find everything they could here. So,
Yeah. I mean, I read that too, and I saw that. I didn't know about the phone call. I knew about him moving some vehicles because of, the snow and the plowing and stuff. Like, I mean, what does that have to do with Karen Reed? And like I don't get it.
It's just another until you get the explanation. So we didn't have the explanation from Brian Higgins until the trial.
Got you.
So until you
him
get
going back there, yeah.
Why are you going to work at 1:30? What's going on? So and any odd thing that you can kind of do there. But now once you get the explanation. So another one with Brian Higgins was he went to a military base to destroy his phone. Bum,
Yeah,
bum,
I remember that
bum.
one. That one was
But
one that's
again, where he lives is on Cape Cod.
yeah.
And the towns on Cape Cod do not have town trash pickup. You have to take your own trash to a recycling center run by the town. And as a military veteran, there's a base right on the edge of the Cape where you can go through that base to get to the mainland.
Mhm.
Now, on that base, as a military veteran, he gets access to discount gas, discount food at the general store.
Right.
And so it's kind of obvious that what he did was he took his phone and threw it out because he doesn't have trash pickup at his house. And so that was a free way to just toss it in a dumpster or in a garbage pit or something like that. There was nothing nefarious about it, but it's just like everything in this case, it's presented as something really spooky, but then you get the mundane explanation and it's not. Now that's not to say that the butt dials, you don't really know if that's is that suspicious. I mean, you're never going to explain a butt dial, nobody really can, but everything else has turned out to have a mundane explanation.
Yeah, I don't know why did he destroy his phone is kind of interesting, and I'll get back to that in a second. But yeah, no, everything else makes sense. Somebody had asked why wasn't there pictures taken of his vehicle by the tow truck person or anybody else. I mean, I've never seen that happen before in my police career where a tow truck gets there and it getting towed is recorded.
Yeah.
Like what we have usually happen is we've already taken pictures that we needed of the vehicle.
Yeah.
And then
They did not do that though. The troopers did not take any pictures.
well, I mean, if
Yeah.
there's pictures that need to be taken, I would have taken pictures of the vehicle then.
Right.
To be honest with you, but pictures would have been taken of the vehicle, and then they go. I mean, I wouldn't have taken pictures of it before it gets onto the truck or after or in the Sally port or
Yeah.
any of those places. Like I don't recall anybody ever going to that extent. Now, not taking pictures of the car before it's towed, that's lazy. You probably should have done that.
Yeah. Yeah.
Yeah.
I've always wondered that too. We've talked about it many times. Is that sloppy or not? I don't know. But you're saying that you would have done it.
I would have done it. I would have taken pictures
Yeah.
of the car. If,
Yeah.
if I'm towing it and I'm thinking that it's used in its potential weapon that was used, yeah, I'm gonna take pictures of where I found it, 100%.
Right.
And so
Right.
why they didn't take pictures of it, that could have been an element thing too,
Yeah.
Let's get it back
Yeah.
to the Sally port. Let's take pictures of it there.
Right. It was snowing hard.
Yeah. I mean, what can you get? What are you going to see? I mean, that's probably what the explanation is. I mean, the car was no longer in the same condition as it was when it was when it struck him. And if it was snowing, which it appears to be snowing fairly heavily as it's pulling into the Sally port,
Yeah.
I mean, what are you going to get off of that? Just a
Right.
bunch of pictures of snow in the air.
Yeah.
Because the camera doesn't see through it. So
Yeah.
that might be the reasons why. I mean, if I'm in that situation and it's blizzarding and I can't get a clear picture of the car and it's just covered in snow already, my next thought might be, all right, let's just get it to the Sally port, let it start to melt, and as it melts, we'll take pictures of it.
Right. Especially because the taillight housing would have filled with snow since it was exposed, and it would have been to a degree covered in snow. Although Officer Barrios from the Dighton Police was able to see that it was broken, and he described the right corner as missing pieces. At least that's what he said in court. On his original report, he just said right taillight damaged. So we can't tell much from that, but he would later say that. Just to answer Debbie's question, the motion will absolutely be denied. Absolutely. I thought that. Not that I don't think it's completely without merit that some of the things in the motion to dismiss might be a little bit of a troubling or something like that, but nowhere near enough to cause this case to be dismissed. And after we've heard the explanations, I went over earlier in the show, Daniel, from the state's rebuttal to that. No way. There's no way that this case is going to be dismissed, and that really is their best hope, is to get it dismissed at this point, because, as me and Daniel are saying, the evidence is just overpowering.
I don't think that. I think a what's it called? A mistrial is not something that usually goes into the favor of the defendant, because the second time around you have the tactics of the defense. You know what they're going to do. You know what they're going to say. You know what they're going to attack. They can't change those things. You know what I mean?
Right.
Now, the prosecution, you can say, all right, for instance, we didn't think that, we would have thought that no dog DNA would have been enough to slam the book on the fact that this was not a dog attack, but it didn't. Well, now they have the opportunity to go back in there and have their own expert who can now rebuttal the defense's expert to say that was a dog bite, and with some actual evidence and proof and logic, and show that it wasn't. Et cetera, et cetera. So those things can happen. I think that a lot of their arguments are falling and failing. The federal investigation being over and not having any findings against anybody was like a nail in their coffin, because that proves that there was not something that was happening with the Alberts or anybody else nefarious. It's just what it is. I think that Turtle Dude and Karen Reed are I think they've said some things about that they know for a fact that that's not the case, but I don't know. I haven't.
I am 100% sure. I can only, when you have sources, unfortunately, you can't reveal the source.
Right.
But something like that or anything, I'm going to be extra careful in. And I'm going to be careful how I say it, but I know for a fact that the U.S. Attorney's Office reached out to the Mass State Police, the Norfolk County DA, and the Canton Police. And then representatives from the Norfolk County DA's office reached out to the witnesses. And this is just fact. Now, I don't know when the federal investigation ended. My guess would be at the end of July, because that's when the ARCA contract ended, but I'm not really sure. So someone just sent me a video. Let me put this up. This is Karen saying something that might be interesting to us.
Okay.
Karen says John's mother seemed to keep her distance.
They had pulled into the driveway before me, so I was presuming she saw my cracked taillight and was thinking, did you hit my son?
No, that's what she was thinking.
Yeah. She was trying to. All right. So the reason I can give some insight as to some background as to why she tells this story. When you this is something you wouldn't know if you didn't know what was going on inside that house. But when you know the details, I can shed some light on it. So Paul O'Keefe has described, and keep in mind, Paul O'Keefe got along good with Karen. The whole family did. There's no hostility before this between them. And so Karen, when she gets out of the hospital, she had been Section 12, and her father picks her up. She calls up and she says, "Can I come and see the kids?" So Paul's like, "Yeah, of course." They weren't suspecting Karen. And so we see in the video, they show up, and eventually Karen's brother shows up with his wife too.
Mm-hmm.
But inside the house, what troubled Paul for the first time was the fact that, so John has a nephew and his niece. The niece is like 14. She's already home. She's distraught, or she gets home maybe right before Karen, I think. Then his nephew is 10, and he comes into the house with Karen already there. And now he learns about his uncle, who's basically raising him as a father. And
Right.
the kid's already lost his natural parents, so he's inconsolable. And everybody in the room was broken up by this scene. These kids so upset. Everybody's crying. But the one person that didn't seem at all moved, according to Paul, was Karen. And this is why she's telling this story here, because she thinks maybe that'll come out in trial, I guess, now. So she's trying to explain to, at least to the public, or why she was acting a little bit bizarre. And she's saying this because John's mother was being cold. And she's saying that she thinks John's mother was being cold because John's mother would have seen her broken taillight when she came in. So John's mother suspects. So that's why she's saying it.
Interesting. Well, to me, the way that came off was her own guilty thoughts. Are people noticing my cracked taillight and realizing I hit him? That's the way I took it. The first time I heard it, the way she said it.
Right.
But yeah, no, given that background, yeah, for sure. Everybody noticing that she's not being moved by this one notion. Again, that's probably just her subconscious, going through everything that they've been going through, is acting in the manner that she's acting because she's probably in that mode of like, oh my God, are they going to find out that I did this?
Right. And everything she says on these TV interviews is very purposeful to what she has on her mind at the time. And so as the public's awareness of certain pieces of evidence changes, she changes her story. So for instance, in earlier TV interviews, she said that when she dropped John off and saw him go into the house, she waited for 10 minutes in the driveway and was texting him. But the phone records show she did not text him, and she probably didn't call him. The first call was at 12:33, and she was probably on the road at that point because she got home around 12:36. So she lied. Or misremembered, I guess, if you want to give her that. But she no longer says that now. So this is Kerry Roberts here. Kerry Roberts was a friend of the O'Keefe, a very close friend of John and the O'Keefe family. She's prior to this day, she had only heard of the McCabe's, had met Jen McCabe once. So and same with the Albert. She wasn't in that circle. She was in the O'Keefe circle.
Are you familiar with a Ken officer named Michael Lang?
Yes.
How do you know?
My daughter and his daughter are friends.
So beyond your daughters being friends, Is that someone that you know or that you socialize with or anything like that?
No, I mean, they've come over to my house, his wife and him, one time, but we don't.
Before I finish this, Daniel, just a little background on this for you. So, in the motion to dismiss, the defense is talking about. So, during the trial last year, their data guy decided to look at the location of Jen McCabe's phone, and the next day, it was at a certain house for a period of time, and he looked up that house and learned that it was Officer Lank's house. Now, Officer Lank was the cop that went inside the house with the Canton police at about 6:30, a little before that. So what they try to do is figure out, is there something suspicious here? Was Jen McCabe and Kerry Roberts there to get together their story or something like that? So this is the clip. So people have to remember that. So the defense was aware of this when they questioned Kerry Roberts, and they chose not to cross-examine Kerry Roberts at all.
Hang out with him socially. His wife and I are friends.
Now, at some point around this date, around January 29th, let me ask you, turning to the next day of January 30th, do you recall what you did that day?
We went over to the O'Keefe's house. My daughter, Jen, and Jen's daughter, and myself.
And following that, do you recall where you went?
My daughter wanted to get dropped off to her friend's house at Mike Lank's.
And so after leaving the O'Keefe's house, is it still the same as far as yourself, your daughter, Ms. McCabe, and her daughter?
Her daughter stayed at the O'Keefe's.
And as far as Ms. McCabe was concerned, after dropping your daughter off, did you go anywhere with Ms. McCabe after that?
I just stopped at Mike Lank's house, I think, and then we went home.
And so when you got to your daughter's friend's house, who, if anyone, did you speak?
Mike's wife came out to the car to see how I was and how the O'Keefes were, and so she talked to us for a little, just asking how everyone was.
And if you know, ma'am, do you know about how long that conversation was?
I mean, I'm a talker, so it's probably a while. I'd say at least 45 minutes.
Was that a conversation like through the window, or did she get in the car? You know,
I think she got in the car. She was in the back seat because it was freezing.
From that conversation, do you recall anything beyond sort of how people were doing or anything? Did you discuss anything about sort of what you had seen or what you had heard before on the 29th?
I don't recall. It was just a regular conversation. Well, not regular, obviously, but she was more concerned how the O'Keefes were doing, how the kids were doing.
And then after you left from the Lang's house, where did you and Mr. McCabe go?
I don't know. I'm assuming home.
All right, let's stop it there. So, officer, if the insinuation is they're getting information about the case from Officer Lank, well, Officer Lank was not part of the investigation other than what happened in the morning when he was at the crime scene. So they weren't going to learn anything new from Officer Lank. So it's really much to do about nothing. But that's the defense's job, obviously, to do that kind of thing. So
yeah, I mean, they could have been there for a lot of reasons.
Yeah.
You know, I mean, she could have gone up there and said, none of your business what I was doing there. And I mean, at the end of the day, they could have been there for many reasons. You know, to me, her just admitting it. And I mean, did she deny it at any point?
no, I mean, she didn't deny. So they went, her daughter is best friends with Officer Lank's daughter. That was the reason for going to the house. And while they were there, Officer Lank's wife came out and sat in the car and they talked, which is, I mean, Kerry has said she likes to talk a lot. And
Right.
This is the big event of their lives. It's a big tragedy, particularly for Kerry, who was really, really close to the O'Keefes. So it's not really surprising that all these people want to talk about it, right? I mean, we're talking about it now. We don't even know any of these people. I mean,
True.
so Ashley has a question for you. if a cop walks out of their home with a police investigation on their lawn, wouldn't that be considered interference with a criminal investigation? So the question is, I guess, is why Brian Albert, who is a Boston police officer and it's his house and it's his lawn, would you expect Brian Albert to come out of the house during a blizzard?
I mean, maybe look out the window, step outside, as far as probably the extent of what his involvement should be.
Yeah.
I've said this story before. One time I almost got in trouble because I was off duty and I saw a hit and run, and I followed the vehicle. And what ended up happening was the vehicle ended up, obviously seeing that I was following the vehicle, pulled over, and I didn't, all I had with me was my wallet with my badge in it. And I probably shouldn't have stopped, but I did. And I didn't say anything other than just like, hey, stay there. Identified myself, stay there, wait for our officers to get there. And then after the fact, I got a stern talking to, because in my policy, it states that if I see a crime while I'm off duty, that I am to just report and stay out of it. Can I enter into it? Cannot do anything. I am not on duty. There's legal and liable reasons and a bunch of other things that can happen and have a negative impact. I'm not properly, dressed or ready for a situation if one were to arise, and if somebody else got hurt, I mean, it could just turn into a huge ordeal. So I know for a fact that you probably shouldn't do anything other than report what you know and see it and stay out of it. Now, if somebody's like actively passing away, that's a different story. Or if you have somebody's life in danger, yeah, 100%. But if you're acting like if those aren't the cases and you're seeing something happen, you can get in trouble for it. You're supposed to call, report it, do what you would expect a civilian to do almost. Like I said, exigent circumstances are different, especially if you're equipped with your weapon with you off duty and somebody's life is in danger, then yeah, you're probably expected to act. But if it's something that is like this, where there's a bunch of cops already outside, the law enforcement's there, first responders are there, yeah, you don't want to put yourself in that position. It's probably also better that he didn't, because if he hadn't, let's just say he'd gone out there and he started messing with the scene, then people would be saying, oh, he's just making sure that his DNA is there and a bunch of other crap.
Right.
That people would have said. So it's probably in his best interest that he didn't go out there and done anything or touched anything. But to me, him coming out, going in or out, I mean, what can he do at that point? What is he supposed to do at that point? He's intoxicated. He's been drinking. He's not equipped for the occasion. He's not in the right mental state. He's not fit for it. Being under the influence. What can you do? I don't see that as being suspicious.
Right. So I just want to respond to a little chat situation here. So somebody was saying they're going to leave because this person named Bonnie is bothering them. So while you were talking, I scanned through, and I want to make sure the rules are clear here. People are not only welcomed for having dissenting opinion, they're cherished, but they have to be respectful. No caps, no putting in all cap words. And as I scrolled through, I did see that, but I didn't stop on that. But then I see her makes a comment, how much are the McAlberts paying me? So that's it. So you're gone. If somebody is accusing me of being corrupt, and just even using the word McAlberts is enough to get you banned here. So you're not allowed to say McAlberts. You're not allowed to say Plevin or things like that. But if you want to be respectful and have difference of opinion here, you're not only welcome, you're cherished. We don't want an echo chamber. But if you're going to come in here and be an ass, you're going to get bounced. So James Clay, why didn't Alan Jackson or Yannetti stand up and defend themselves? Instead, they let the other lawyer speak for them. So that they're talking. I don't know if you followed this last week where.
I did. I saw that. I was watching that. My only thought was they don't want to put themselves further into the hole, by speaking and saying something. They'd rather have somebody else who wasn't a part of the first trial go up there and talk. That way, if they make a mistake or they say something they shouldn't, it's a completely different aspect versus if Alan Jackson or Yannetti go up there and say something that's proven that is wrong again. You know what I mean? I mean, they're already in the hot seat for it. But I think it's also a huge thing to see that, because the fact that they're not, and this tells you that there's probably more that's there, which was one of
Right.
my first suspicions that I mentioned to you. I was like, when they didn't automatically object and do all these other things in trial, as this was going down, or even say, hey, we want to say something at the end. I thought it was because they didn't know what else they had on them, or they didn't know what else they may know that they think they have on them. And
Right.
that could be another aspect to this too, is like, hey, they don't want to further put themselves in a hole.
Right.
And if that's the case, that means that there's
Exactly.
probably room
Yeah.
for them to put themselves in a hole.
Right. That's it seems likely. Now, I personally do not believe that the lawyers will be removed from the case. There will be some kind of a sanction. I believe that the judge may change the instructions a little bit in this case, where the defense team is no longer allowed to say that the ARCA guys are independent. Now, I'm not a lawyer, so I'm basing that on a sense of fairness more than anything. So maybe there may be a legal argument against that solution there. But I believe that the idea of presenting these people as independent, no, they should be presented as regular defense experts, just like anybody else, so the jury can factor that in and say an expert on either side could have a bias. Particularly, I would say defense lawyers, but yeah,
But
defense experts.
the only way that's going to fly as anything is if the prosecution comes up with their own experts to explain how
Right.
this happened.
Yep.
They're going to need to
100%.
do it. If they don't, and they just let that fly like that,
Yep.
that's not gonna. You're gonna find yourself back to square one.
Yep. 100%. 100%. I think the way the prosecution tried the case last time, they're lucky they did as well as they did. So the defense's best chance was the last time, but they're not going to make those same mistakes again. I don't think they would have, even if they had the same prosecution. They would have learned and built on it, but now you have a much more competent, thorough prosecutor. But yeah, they get the chance to learn. They really lean too heavily on Karen's statements at the scene. And the problem with that is those statements are open to interpretation. She's not recorded saying them. So it's what various witnesses heard her say. And then even if they were accurately remembering what she said and didn't somehow accidentally influence each other back at the fire station or the police station, don't really know what was in her head when she said it. So I think people were going to, it's okay for people to factor it in, but I think in a lot of ways, people are going to be like, we're not really sure here. I'm talking about a jury. You're not going to get 12 jurors to agree that they're sure what Karen said and what she had in mind. So they're going to want to go to the nuts and bolts evidence.
Yeah.
And I think that's the way it should be. A jury should go to nuts and bolts evidence as much as possible, especially to something where there were no witnesses to the crime.
I agree. I agree.
Yeah. So let me just, I want to call it a night, Daniel, but I got time to ask you, have you followed at all? Like, what's going on with the Gene Hackman thing? I haven't followed it closely, but it does seem some weird stuff is emerging there.
So what are the suspicious stuff? You have people who have died at the same time.
Yeah.
There is a dog that passed away 10 feet away from one of the victims. They are in different locations of the house. A door was left wide. I'm not certain it was wide open, but it was open and not necessarily unlocked, but actually opened. And there was no sign of carbon monoxide or gas leak of some kind. And so you have just those mere fact there is why they're looking into this as being suspicious. There's no sign of foul play. There's no sign of rummaging through the house or anything missing or things of that nature that would be. I think they put it in the and they have a search warrant affidavit out, and that I think the officer used the term nothing out of place. But they're doing the due diligence just basically because they both passed away, presumably at the same time or around the same time. And there was 3 dogs on the property, one that was deceased, 2 others that were alive. One was inside of the house, one was outside of the house. From what I've heard, the third one, the one that did pass, I think it was inside of a kennel. So, I think that in the last live I had, um, the last point of contact was 9 days ago. So they've been passed away for at least 9 days, if
Mm.
not 2 weeks. And I one of the
What
most
about the what
suspicious
about the
things.
pills too? What about the pills? The
Yeah, there
opiate
was
pill
some
bottle?
pills. There was so with the wife of Betsy, she had on the ground there was a heater next to her that they said that had she fallen suddenly would have fallen with her off of the counter where there was some pills there as well. I believe they were like heartburn or anti or like some sort of blood pressure type medication. Not too certain, but they and she was on the ground.
So
Uh,
could the pills have been a cause of death or not? They're just not.
I mean, that's something that you're gonna have to wait for a toxicology report from
Yeah,
the autopsy because
yeah.
there's nothing that they can see, especially given how many days it's been, that shows that there's
Right,
uh, some sort of poisoning or
right,
overdose. Like whatever symptoms that may have had is
right.
possibly gone from this
But if
point
you
of view.
if you were gonna kill yourself, would you use blood pressure pills?
I don't know. And so Gene, the way he was found with his pair of sunglasses right next to him. It appears that he just abruptly fell down and went down. It doesn't sound
Yeah,
like he
right, right.
was
And
attacked
he
or
was in
anything.
his mid-90s, so,
Correct. So we probably assume that if I would have assumed anything, if me doing my little psychic police intuition thing, he probably went down. I'm assuming she panicked, went to the prescription pills, try to find something that'll help him during his episode. And
oh,
during
okay.
that, she probably had some sort of episode on her own and fell down.
Oh,
Um,
man.
that's what I would have assumed happened.
Mm,
If I were to, based on the things that I'm reading,
mm.
I don't know. I don't know if it would have been something where she would have taken her life away. Typically,
And she was only in her early 60s, so would have
right.
been
I would have assumed that if she did something like that, like, oh, I can't live without him, I have to be with him, and took pills or something. When I don't know if those pills would have had that effect on her that
yeah,
quickly, like, oh, let
yeah,
me drink them and boom, down to the ground. I think
right,
it would have taken some time.
yeah,
Two, I would have assumed she probably would have been with her husband. If
mm,
she was going to take her life because she couldn't live without him, I would
right,
assume she would have taken the pills and gone and sat down until she
right,
passed. You know what I
right,
mean? And maybe even
yeah,
written a letter, notified somebody of somehow, sent out an email of some sort like, "Hey, come check on the house
mm,
tomorrow, please." Something of that nature.
mm,
Especially when it comes to like 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 females when they commit something like this, it's usually um they there's a sense of dignity that comes with it. That's why you rarely see like a female take her own life when it comes to like the head or anything like that. If there's gun shots or stuff, it's usually the heart, chest, stuff like that.
mm,
Um, you know, those type of things, digestion of pills and stuff. And and in this instance, if that was the focus, I would have highly suspected that she would have um been with her husband and probably would have presented that a little bit differently than
yeah,
just him having him stay in the position that he was falling on the ground. You know what I mean?
yeah,
Which is like I'll talk real briefly about this one crime scene that I saw that made me think of that I would have investigated it a lot further, but it wasn't. And I was a rookie at the time. I got called out to a person who had passed away. When I got there, there was a, lady who was deceased on the ground in her bedroom, and her bed was made. And it looked like she had just looked like she had laid in bed, like made the bed, opened it just enough to lay down in it, and then open it
mhm,
enough just to get off of it, and
yeah,
walk up in front of her bed where she collapsed. Now she was in her underwear, and in in her restroom were was a rosary, there was a candle, there was a there was a mixture of chemicals that she we presume that she drank.
mhm,
And there was also, I believe, I want to say there was a note. My memory, I mean, this was almost 2 decades ago. And so the part that bothered me the most was that everything was nice except her. She
Mhm.
wasn't nice. She was in her underwear. She wasn't dressed right. And her husband, who was an illegal at the time, and I don't, and they were going to go through a divorce, and there was supposedly something about if they got divorced that he may be going back to Mexico. He showed up at that house. So he was supposedly like in a town about 4 hours away, but he showed up within 2 hours, and he
Mhm.
wanted to get into that house, and nobody notified him that she had passed away.
Mhm.
And so I always thought that she got drugged and that something happened to her. And I always had this feeling that the husband had something to do with it, just because
Mhm.
I was like, I hadn't, we just had detectives there when he showed up.
Yeah. Right.
Like she had been passed away for 2 hours or whatnot, and
Mhm.
nobody called him. Like he was already living with another woman. He had his own other thing going on, and he was like, "I need to
Mhm.
get in that house. I need to get in the house. I need to get an apartment." He was a problem for like a day and a half, and I
Mhm.
kept telling the detectives, I was like, "Look, like, how does he even know, and why is he even here at
Mhm.
this time? Like, she just passed, like, and he shows up a couple of hours afterwards when he supposedly lives further down the road."
Yeah.
Like those things didn't make any sense to me, and that scene just seemed orchestrated. I mean, it
Right.
looked staged to me, and
Right.
but I was a rookie officer, and I personally think somebody got away with something, but
Mhm.
that's just my personal thoughts on that one.
All
I
right.
don't remember why I went with that story, but
Well, maybe someday we'll take on the Ellen Greenberg story.
oh yeah, we were talking
Let's
about Gene Hackman. There we go. I remember now.
let's not clue the audience into what we think on that case yet.
Yeah,
But the one in Philadelphia.
now, I'm not familiar with it, man. To be honest
Oh,
with you.
okay. This is one of the big this I don't know, was it 6 years ago maybe, but a young woman in Philadelphia, they live on the sixth floor, where she lives with her fiance. The fiance goes down to the gym in the building to work out. He comes back later, and she's used the inside lock to lock it,
Yeah.
and he can't get it. So he gets the building manager. They can't get in. So he eventually breaks in, and they find her stabbed to death.
Oh, jeez.
It was ruled a suicide. And to this day, there's this huge, a large audience, including a percentage of my audience, who believes she was murdered by the fiance.
Mhm.
So there's this may have caused the governor of Pennsylvania was the attorney general at that time, and he was the leading person to be nominated by Kamala Harris to be his vice presidential candidate. I'm sorry, her vice presidential candidate, and she ended up not going with him. She went with the other guy, but it
Hmm.
may be because of this. Just such a large percentage of the public thinks that he is somehow complicit in a conspiracy to cover up the murder of Ellen Greenberg. So we
I
might take
don't
that
know.
on.
That
But
sounds interesting. I may need to look into that one. I've never heard of that.
there's some interesting aspects of it that I would like to hear your thinking on. And I haven't looked deeply into it. But I do. There is a podcaster who has made all the files available on it, so we can research the hell out of it if we need to. But we can also just look at the basic aspects of the case. So she had like 22 wounds, but other than the last one, they were mostly shallow, and most of them were on her back. So this is one of the reasons people think that you know
Huh.
that she didn't stab herself. But so we'll save that for another one.
Sounds good, my man. That'll work for me.
All right.
But
Thanks for being here, Daniel. Very much appreciated having you.
yes, sir. Thank you. Thank you for having me. Yeah, have a great night.
Okay. Good night. You too. All right. Good night, guys. Thank you very much. So next week we have 3 hearings: Tuesday, Wednesday, and Friday. And I got notified this week that they want me on court TV for those same nights. So Tuesday, Wednesday, and Friday. So it'll be similar format to last time with me, Nick Rocco, Joe Krowski, and Wayne Dennison, where it's kind of they want a more loose, free for all kind of show. So from like, I think they said it was going to be from 8 to 8:50. So that'll be it. Now, Wayne takes a little bit more the defense side. Obviously, Nick Rocco does, and me and Joe take more the other side. Wayne's I really respect the hell out of his opinions on the case, and he seems like a really good guy too. So it's it's a good format, and we'll see how it goes. We're trying to figure out this new format of you don't want to interrupt the other. They don't want it so regulated. So he starts the question. He started the question with Joe, and then we're supposed to determine on our own who's wants to go next. But I'm sure each one of us is ready to jump in. I know me and Nick are, and so but we're all trying to be polite. So we'll see how it goes. So next week's going to be a very busy week. All right, guys. Thank you very much, and enjoy your weekend.